Pardon to mention, Your Lordship, CRLMP number 127 of 2020, Your Lordship, for quashing of the affair and other consequential proceeding, Your Lordship. Yes,
Lordship, your Lordship has allowed the person to go on bail for 3 months, but surety, to check the surety papers, Lordship, this is lingering already in 4 years jail custody, the present prisoner.
Pardon to make a mention, my lord, one bail application modification of order, my lord. And another is, my lord, item number 194 of the weekly list, my lord, permitted to withdraw, my lord. 194.
194.
194.
That is BLAPL number
10595
10595 of 2022.
My lord.
Arjun Dheer.
My lord.
Okay. Disposed of as withdrawn.
Another criminal appeal, my lord, fresh admission, bail in nature.
A fresh criminal.
Well, it's one last week I mentioned one item that was in a weekly list, and that was a criminal revision matter which we had filed for challenging the discharge petition under section 239. Your Lordship had taken that into record, that mention memo, but again it has been listed by further pushing it back to 256 number item.
We'll see.
21st is the next date of hearing.
Pardon me, Lord. Criminal Appeal 122/2009 will be listed. Kindly, madam, is 6 months valid conviction of 6 months and
criminal revision relating to CBI matter, my lord. It's filed last month. It's not come up for hearing, my lord.
Give it. Yes.
Pardon me, Lord. CRLMP matter of the year 2019, my lord. Stay is there. I am appealing from the opposite pattern mode to filing I for vacation of stay, my lord.
Give it.
My lord, I beg pardon to mention, my lord. Cecil adjourned today, but not listed, my lord.
I beg your pardon, I am in VC, my lord.
Yeah.
One CRLA number 737, fresh matter, 737 of 2023.
Yes.
Yes, my lord. And another one CRLMP 450 of 2023, your lordship, the interim order passed by the Judge Family Court Bhubaneswar, your lordship has issued the notice. May I pray this matter may be taken up because...
Okay, give it.
My lord, I'll give the memos.
Weekly list.
May I please, your lordship? My lord, kindly come to page number 81 of Annexure 1, my lord. First paragraph towards last, my lord.
Yes.
Both the convicts Shivaram Sahu and Mangalacharana Sahu are sentenced to undergo rigorous imprisonment for 10 years and to pay fine of rupees 1 lakh each in default, to undergo rigorous imprisonment for 1 year for the offence punishable under section 20B2C of NDPS Act, my lord. That is 22 kg of ganja, my lord.
All right, admit call.
My lord, another appellant in CRLA 687 of 2023, my lord. Shivaram Sahu, that is order dated 3/7/2023 of your lordship, has called for trial court record in that matter, my lord.
Okay.
Kindly come with that record.
It is stated that the co-accused Shivaram Sahu faced trial.
That is also conviction.
Along with the petitioner and convicted by the London Trial Court has preferred a separate appeal, that is CRLA number 687 of 2023, which has already been admitted and trial court record has been called for. The registry shall verify whether the trial court record has reached in the said case or not. Henceforth, the matter shall be listed. This matter shall be listed along with CRLA number 687 of 2023.
Obliged by.
What is this, Mr. Das? Mr. Das,
My lord.
what is this matter?
My lord, NDPS, my lord, 10 years, 1 lakh, my lord, 20B.
Okay, I'd admit call for the trial court record. Interim applications for bail and stay relation of mine be considered after receipt of the trial court record. Learned counsel for the appellant shall supply the deposition copies of all the witnesses to the learned counsel for the state.
Item 5.
Appellant has been convicted under section 20B2B in the running case 34. My lord. He was on bail and the conviction under 20B2B for 5 years RI and a fine of rupees 50,000 at the bottom. My lord. He was on bail during course of the trial, and allegation that he was found with a bag in the roadside. His bag contains 4 kg of contraband ganja. Prosecution case.
Yes, Mr. Mel. Admit he was on bail after conviction taken into custody. Bar under section 37 not applicable. No chance of early hearing. Bail allowed. Stay realization of fine.
Item 8.
Your Lordship may kindly peruse the previous order, my lord. Your Lordship directed the registry and note whether defect number 4 as pointed out by the SR is cured of.
Okay, peruse the now it appears that the court fee of rupees 13 has been paid and defect number 4A as per SR has been removed. So what is this appeal for?
My lord, appeal for conviction RI for 7 years in 326 of IPC and 7 years in 307 of IPC, my lord. There is a delay application also, your lordship. Condonation of delay. Flag A. IA number 1023 of 2023.
350 days.
1023 of 2023, my lord. Flag A.
Yes, Mr. Das. So delay be condoned 7 years sentence is there. IN number 1023 of 2023. This is an application for condonation of delay. After hearing the learned counsel for both the parties and going through the averments taken in the interim application, and since the appellant has been sentenced to undergo RI for 7 years, I am inclined to condone the delay in filing the criminal appeal. Accordingly, delay is condoned. IA is disposed of. Hard admit, call for the trial court record. Let the learned counsel for the appellant supply the deposition copies of the witnesses. To the
Already supplied, my lord.
Already supplied?
My lord.
So, have you given to the court?
Yes, your lordship.
Okay, who is the injured and who is the doctor?
My lord, PW number 1 is the informant, 2 is the eyewitness.
No, come to the injured.
PW number 5, your lordship.
PW 5 is injured. Who is the doctor?
Sorry, my lord. PW 5 is the doctor, my lord. And PW 7 is the injured man.
Four injuries are there and has been opined to be grievous in nature.
My lord.
Hard and blunt weapon and CT scan of the brain was conducted and it was found that multiple fractures of left skull bone is there. Subdural hemorrhage in bilateral frontal lobes, left parietal and left temporal lobes. And then how many days he was hospitalized?
Almost a month, your lordship, the victim.
So, you are in custody during trial?
Yes, my lord. Since 28th November 2019, my lord, I am in custody.
So almost 3.5 years you are in custody.
My lord.
What about criminal antecedents?
9 months.
How many criminal antecedents you have got?
So, as per the instruction received, this is the first case, your lordship. There is no criminal antecedent.
Yes, Mr. Das.
Not often.
Okay. Can you get it next week? All right. The learned counsel for the state seeks some time to obtain instruction about the criminal antecedent, if any, against the appellant. This matter in the week commencing from 24th of July 2023.
Grateful, man.
Mr. Patro,
Miller.
what is this? IA has been filed for change of nomenclature to FAO.
Miller.
That is to be registered as FAO.
Miller. But he has not sought the copy, Miller.
Chiranjeev Vidyabhushan A. Mishra B. Patnaik. Okay. Pass over them.
Miller.
Item 14.
attachment proceeding under the OPID Act, it should be registered as FAO instead of CRLA.
You have to file an application, interim application. Mr. Dev Prasad Das, Land Council, appearing for the appellant, submits that he intends to file an interim application for conversion of this CRLA to FAO, giving copy to the Land Council for the state appearing in the OPID Act matter. List this matter immediately after the interim application is filed.
Item 17.
May I please? The petitioner, the appellant is convicted under 341, 294, 323, 325, 34 of IPC and sentenced to 3 years imprisonment.
Which paragraph?
34, page 34.
Page 34.
Yes, madam.
So substantive sentences have been directed to run consecutively.
Yes, madam.
So 3 years for 325, then
1,000,
okay, that is there.
2,000 fine.
You are on bail during trial.
Yes, madam.
And after conviction also you have been, all of you have been released on bail. This appeal has been admitted.
No, madam. And some defects are there.
Why it has come in the orders matter? It should have been come.
Yeah, showing that a vernacular certificate is filed.
All right, admit call for the trial court record. The appellants were on bail during trial. Bail allowed, stay realization of fine.
Okay.
Item 18.
My lord, item 18.
Yes, Mr. Das.
My lord, I have filed this present application challenging the impugned order, my lordship, which is that initially we filed a section 3 criminal law amendment ordinance application. And along with that, we filed a petition under section 4 of the criminal law amendment ordinance 1944. My lordship, your lordships will find from the impugned order that while the law and trial court at page 12, my lordship filed accordingly the application under section 4 of ordinance 1944 is disposed of, and in the next paragraph, last part, 6th line, hence the criminal miscase is posted to 29/3/23, awaiting further order of Honorable High Court. What has happened, my lordship, earlier 3 criminal miscases have been filed. My lordship, we registered a FIR. Investigation is going on, still it is going on. And in the meantime, main accused, respondent number 1 and 2 absconded. NBW was issued, and 82, 83 recourse was taken, and on that attachment was made, my lordship. And thereafter, on surrendering the respondent number 1 and 2, NBW was returned. And we filed a section 4 of criminal law amendment ordinance for ad interim attachment.
and that was disposed of, saying that that in criminal miscase there was a interim order that no coercive action shall be taken against the petitioner.
Okay.
When the application was filed, and basing on that order, my lordship, the London court below disposed of my section 4 application. That is only no coercive action against the petitioner was there. And basing on that, accordingly, the application under section 4 of Ordinance 1944 is disposed of. And in subsequent paragraph, the criminal miscase is posted to 29/3/2023, awaiting further order of the Honorable High Court in criminal miscase number so and so.
Who has filed that criminal miscase number 2842 of 2000?
IO has filed the. IO has filed the vigilance has filed the application.
That's CRLMC.
Yes, my lord.
For what purpose?
My lordship, that CRLMC has been filed by the present respondent in this honorable court. But so far as the section 3 application is concerned.
No. I am telling about that he has mentioned in the last 4 lines.
Yes, ma'am.
That awaiting further orders of the Honorable High Court of Orissa in CRLMC number 2842 of 2000.
That has been filed by the respondent number 1 and 2 challenging the imbue.
Just a minute. That means Basanta Manjari Biswal and Nagendra Prasad Biswal.
Yes, madam. So
they have filed that application challenging the NBW. So what order was passed in that?
The only interim application order is there. No coercive action against the petitioner.
No coercive action against those R1 and R2.
Yes.
So thereafter, what has happened? They surrendered.
They surrendered, and that attachment, that NBW was returned.
Okay. So NBW recalled, and they have been released on bail or what?
Bail, yes, ma'am.
Okay. So when that was done, when they appeared and this NBW was recalled.
Yes, madam. In the date chart.
Where is the date chart?
I have given it. Well, it's on 27/9 to 2019. 27/9. Serial number 4 of the date chart. 2019. After execution of the attachment of the properties under section 83 of the CRPC, the appellant returned the warrant on challenging that he filed a.
So NBW was issued first.
Yes, ma'am.
Then they referred this CRLMC.
Yes, ma'am.
2842 of 2019.
Yes, ma'am.
And you said that there was a direction that no coercive action shall be taken.
Yes, I have quoted it in the body of the.
Okay. But when that order was passed by this court?
Yes, ma'am. And that order was passed on 11/10/2019.
So by that time, we
had not filed this section 3 application.
By that time, 82-83 CRPC process has been issued. So whether he also challenged this issuance of process under 82-83 CRPC?
Yes, ma'am.
In which application? You said that 2842 is only NBW issuance of NBW order has been challenged.
Yes.
But after that, it appears that process under 82-83 CRPC have been.
That process of 82-83 they have not challenged.
Oh, no. No.
Yes, ma'am. And after that, as they surrendered, it was returned, released, ma'am.
Now, what is the status of that CRLMC number 2842 of 2019?
My lordship, that is pending, my lordship. And my lordship, I want to clarify your lordship's further action taken by them My lordship, another CRL, your lordships will get from page 2. There are three CRL, one CRLMC 2842 of 2019. The respondents have filed challenging for quashing of the affair. And CRLMP 11, no, that is for challenging the NBW. And CRLMP 1156 of 2020 challenge for quashing of the affair. And again on CRLMC 1645 of 2023 for the self-same prayer as they had made in CRL.
Let us do one thing. Let all these matters come together.
Yes,
Let all these file be placed before the Honorable Chief Justice so that since they are interconnected to each other, let it be decided so that it would be better.
Your lordships also can call for.
No, it is up to, because those things are not CRLMC. I think it is not in my roster, so this is to be Honorable Chief
And
Justice has to.
my very limited prayer in this application, as section 4 application has been disposed of, my lordship, at any point of that time they can.
No, ultimately, you see, when they have challenged the FIR, this is pending. So let it be, all the cases be finalized so that it would be.
And my lordship, in this case, I have filed one is for condonation of delay, and another application I have also filed. It is not in the list, but I have filed since my lordship 26/6/2023.
There is 24 days delay in this application.
Yes, my lord.
So let notice go, thereafter we will pass this order.
And also, my lordship, another application is also I have filed on 26. It must be in the record. Only to
no, give that number. It is assigned to me. It will come next week.
146 IA number 1464
in this CRLA.
Yes, my lord. I have filed.
Since for what purpose that has been filed?
My lord, I have filed for a direction, and that respondents shall not alienate the property or create third-party interest. Otherwise, if they will sell it or transfer it to some.
This delay aspect, we will do it right. This IA number 1372 of 2023.
Yes, ma'am.
Is an application for condonation of delay in filing the criminal appeal. The stamp reporter has pointed out that the delay of 24 days in filing the criminal appeal. You should notice on the question of limitation, the Land Council, Senior Standing Counsel, Mr. Das shall file 4 copies of the interim applications, which will be forwarded to. All of them have appeared in the Special Judge Vigilance Court.
Yes.
Forwarded to Special Judge Vigilance Balashwa. In criminal miss case number 3 of 2023. Since it is stated by the Land and Senior Standing Counsel that all the 4 respondents have entered appearance in the said case, the Land and Special Judge Vigilance shall ensure service of notices of the interim application on the 4 respondents. And it will be intimated to the respondents that the matter will be taken off for consideration of the delay condonation application in the week commencing from 31st July 2023. Land Council and Trial Court shall give a report about the service of notice on the respondents within 1 week from today. For such purpose, the file be placed before the Land Register Judicial, who shall send an email along with the copies of the interim application to be filed by Mr. Das by day after tomorrow. Yes, so give 4 copies by tomorrow or day after tomorrow maximum.
Yes. Another, my lordship, another interim application I have filed since 26/6/2023. That only, my lordship, I have tried status quo, my lordship, that may be. I have filed for direction to the respondent not to.
No, delay has not been condoned, so it would not be proper to pass any other interim order.
Yes.
Let it be. Yes, next.
Item 19.
And it's a free copy of the order.
Okay, free copy of the order be handed over to you. You can, Mr. Das.
Yes, ma'am.
Once this order has been passed, the matter is under challenge. You can bring it to the notice. Obviously, it will be brought to the notice of the court. So we will not pass any order against you that that attachment order which you are saying that.
Yes, ma'am.
So obviously, we will wait. So bring the order to the notice of the court. Yes.
May I please, my lord? Now, this is conviction under 13(2), read with 13(1)(d) of the Prevention of Corruption Act, and also for the offence under.
It has been admitted.
No, my lord, this is a fresh case since a dispense with petition has been filed, because there are 2 cases arising out of same conviction. So therefore, possibly it has been listed for orders. It's a fresh case. Last occasion your lordship was taking up. Since the Vigilance Council was absent, your lordship could not take up, my lord.
Mr. Das is there.
Tuesday, yes. I had informed Mr. Das.
Okay, so you have filed the trial court judgment in which CRLA?
That is in 6th. I have filed in
635. You have filed.
My.
And this IA has been filed for dispensing with certified.
That is, my lord, flag white.
Right.
My.
And what is the conviction and what is the sentence imposed?
The sentence is, my lord, 2 years on each count. That is 13(2) read with 13(1)(d) is 2 years. Then this 418 read with 120B of the IPC is also for 2 years. And fine is there, your lord.
It is concurrent sentence or consecutive?
This is, my lord, 3 years is also there for, my lord, that is, the sentences are to run concurrently.
What is the highest punishment?
Highest is 3 years, your lordship.
3 years.
My.
And you were on bail during trial?
My. I am also continuing on bail.
After conviction, because 3 years sentence. Yes, Mr. Das.
Yes, my lord. 468, under section 468, 3 years is maximum.
All right.
And I have already filed my appearance memo on 13/7.
13/7.
In this case.
Which case? 636 or 635?
636.
All right. 35 you have not filed?
No, 635 by the end of this month.
Okay. So first take down in CRL number 636 of 2023. There is an interim application that IA is 1419 of 2023. There is an application for dispensing with the certified copy, filing of certified copy of the trial court judgment. Mr. Samit Kumar Mishral and counsel appearing for the appellant submits that this criminal appeal is connected to CRLA number 635 of 2023, in which certified copy of the trial court judgment has been filed. And since Both the criminal appeals are to be heard together. Filing of certified copy of the trial court judgment in this appeal be dispensed with. Mr. Sanjay Kumar Das, Land Standing Counsel for the Vigilance Department, submits that has filed the appearance memo on 13/7/2023, and he has no objection to the prayer made in the interim application. Accordingly, prayer is allowed. Filing of certified copy of the trial court judgment is dispensed with. Hard admit, call for the trial court record. He was on bail, bail granted, stay realization of fine. Free copy of the order be handed over to Mr. Das. The other appeal 635 of 2023, Mr. Sanjay Kumar Das, Standing Counsel for the Vigilance Department, submit that he will file the appearance memo by end of July 2023. Admit he was on bail, bail granted, stay realization of fine. There is another application in each of this criminal appeal, that is IA number 1418 of 23 in the first 636 and 1417 of 23 in the 635. These are the application for stay of conviction. You intend to file the objection, Mr. Das?
Yes, my lord. 4 weeks time may be given.
Mr. Das, Land Standing Counsel submit that 4 weeks time may be granted to file objection to the interim application. Time is allowed. List this matter in the week commencing from 21st August 2023. This IA to be listed.
Obliged. Pray for urgent copy.
Yeah.
Copy of the order.
Yes, yes.
Obliged.
Item 20,
Yes, Mr. Satyanarayan Mishra 4. What is this matter, Mr. Das?
302 3 SCST Act.
It's for bail.
Malad,
Bail.
bail.
Notice sufficient on
Malad.
informant.
Malad.
Okay. Pass over. Yeah.
But the appellant is in custody since 3/8/2022.
Notice sufficient?
Yes, my lord. 22/6/23.
You have received the case diary?
Yes.
What is the date of custody?
My lord, date of custody is 3/8/2022.
Charge sheet offenses are?
My lord, annexure number
147.
You have given the copy of the charge sheet, Mr.
Yes, my lord. Yes, my lord. Annexure number 4, my lord. Page
Annexure
number
4.
24.
Okay. Just a minute. So 302 case is this?
Yes, my lord.
Okay. What is the name of the deceased?
My lord, Kailas Meher.
Somebody is also injured in this case.
Yes, my lord. That is the eyewitness. That is Gajanan Meher. I have annexed the statement of that.
Just a minute. Gajanan
Meher.
Gajanan Meher.
So what he has stated about the assault on the deceased?
My lord, the entire allegations level against one person, that is Samir Bhoi.
No. Please come to the statement of that Gajanan.
My lord, kindly turn to page number 17, my lord. That is the
17.
statement.
Just a minute. 17. Okay, please place it.
My lord, ମୋର ନାମ ଗଜାନନ୍ଦ ମେହେର so and so, ମୁଁ ଜାତିରେ ଚମାର ଅଟେ। ଗତ 3/8/2022 ଦିନ ମୁଁ ଚକରକେନ ଭାଟି ପାଖରେ ଥିବା ଗୋଟିଏ ସନ୍ଥ କବି ଭୀମ ଭୋଇ ମହିମା କଲେଜରେ ନୂତନ ଗୃହ ତିଆରି କାର୍ଯ୍ୟ ଚାଲୁଥିଲା ବେଳେ ସେଠି ଆମ ଗାଁର ପପୁ ସାହୁ, ତପେଶ୍ୱର ପ୍ରଧାନ, ସୁନୀଲ ପ୍ରଧାନ, ଜଗେନ୍ଦ୍ର ପ୍ରଧାନ, ଜିତେନ୍ଦ୍ର ବାଗ, ଅମର ସେଠ, ମାନସ ସାହୁ, ସମୀର ଭୋଇ, ବିକାଶ ସାହୁ, ସୁଶୀଲ ବରିଆ, ଜଗନ୍ନାଥ ଏଲିୟସ ଲୋକନାଥ ଭୋଇ, ଦ ପ୍ରେଜେଣ୍ଟ ଆପେଲେଣ୍ଟ, ଯୋଗେନ ପ୍ରଧାନ ସମସ୍ତେ ମିଶି ମତେ ଗାଳି ଗୁଲଜ କଲେ ଓ ଜାତିରେ ମଧ୍ୟ ଆକ୍ଷେପ କଲେ। ମୁଁ ତାପରେ ଆମ ସାହିକୁ ଯାଇ ସେଠାରେ କୈଳାସ ମେହେର, ଗୟାନନ୍ଦ ମେହେର, ନାରାୟଣ ମେହେରଙ୍କୁ ସବୁ କଥା କହିବାରୁ ମୁଁ ଓ ଅନ୍ୟ 3 ଜଣ ଯାକ ଉକ୍ତ ଜାଗାକୁ ଆସି ତାଙ୍କୁ ପଚାରିବାରୁ ସମସ୍ତେ ମିଶି ଆମ ସାଙ୍ଗରେ ଯୁକ୍ତିତର୍କ କଲେ। The relevant person is that ସମୀର ଭୋଇ ଗୋଟିଏ ବାଉଁଶ କଟନରେ କୈଳାସ ମେହେର ମୁଣ୍ଡକୁ ଲକ୍ଷ୍ୟ କରି ଜୀବନରେ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟ ରଖି ମାରିଲା। ସୁଶୀଲ ବରିହା ମଧ୍ୟ ଗୋଟେ ବାଉଁଶ କଟନରେ ମତେ ମୁଣ୍ଡକୁ ଲକ୍ଷ୍ୟ କରି ଜୀବନରେ ମାରିଦେବାକୁ ଉଦ୍ଦେଶ୍ୟ ରଖି ମାରିଲା, ଯାହା ଫଳରେ ମୋର ମୁଣ୍ଡ ଫାଟି ରକ୍ତ ଜୁଡୁବୁଡୁ ହେଲା ଓ କୈଳାସ ମେହେର ମଧ୍ୟ ମୁଣ୍ଡ ଫାଟି ରକ୍ତ ଜୁଡୁବୁଡୁ ହେଲା। ମାନସ ସାହୁ, ଯୋଗେନ୍ଦ୍ର ପ୍ରଧାନ, ଜିତେନ ବାଗ, ଅମର ସେଠ, ବିକାଶ ସାହୁ, ଲୋକନାଥ ଭୁଏ, ଯୋଗେନ ପ୍ରଧାନ, ପପୁ ସାହୁ, ସୁନୀଲ ପ୍ରଧାନ ମଧ୍ୟ କୈଳାସ ମେହେର, ମୋତେ, ନାରାୟଣ ମେହେର, ନିରଞ୍ଜନ ମେହେରକୁ ବାଡିରେ ପିଟାମରା କରିଛନ୍ତି, ଯାହା ଦ୍ୱାରା ନିରଞ୍ଜନ ମେହେରର ଅଣ୍ଟା, ବାମ ଓ ଡାହାଣ ଆଣ୍ଠୁରେ, ପିଠିରେ ବେଲଛାରେ ପିଟିଛନ୍ତି ଓ ସମସ୍ତେ ମିଶି ଚମାର ଜାତି ବୋଲି ଜାତିଆଣ ଆକ୍ଷେପ କଲେ, ଯାହା ସର୍ବସାଧାରଣ ଜାଗାରେ ମୋର ଅନ୍ୟ ସମସ୍ତଙ୍କର ଇଜ୍ଜତ ମାନହାନି ହେଲା। ତାପରେ କୈଳାସ ମେହେରର ସ୍ତ୍ରୀ ଘଟଣା ଜାଗାକୁ ଆସିବାରୁ ମହାଦେବ ସାହୁ ଭାନୁମତୀ ମେହେରକୁ ଅସଭ୍ୟ ଭାଷାରେ ଗାଳିଗୁଲଜ କରି ଚମାର ଜାତି ଆକ୍ଷେପ କରି ଜୀବନରେ ମାରିଦେବାକୁ ଧମକ ଦେଲେ। ବର୍ତ୍ତମାନ ସୁଦ୍ଧା କୈଳାସ ମେହେର ବୁର୍ଲା ଡାକ୍ତରଖାନାରେ ଚିକିତ୍ସିତ ହୋଇ ଜୀବନ ସହ ସଂଗ୍ରାମ କରୁଛନ୍ତି, ଏହା ମୋର ବୟାନ ଅଟେ।
So you mean to say that this eyewitness who is also an injured,
yes, my lord,
he has not implicated the present appellant as an assailant of the deceased?
Yes, my lord.
The injured.
Yes, my lord.
Yes, Mr.
Yes, my lord. That's true.
Are the learned counsel for the appellant learned counsel for the state? Learned counsel for the state submits that notice on the informant has been made sufficient. Since Kebe date, what is the date? 22/6/2023, non-appears for the informant. Considering the submission made by the learned counsel for the appellant that the appellant is in judicial custody since 3/8/2022 and he has been charge sheeted under section so and so, annexure 4 is the charge sheet. See and mention the offenses. And after going through the statement of the eyewitness come injured, namely Gajanan Meher, who though stated that the appellant along with others abused him in filthy language and also in the name of his caste, but has not attributed any overt act in the assault of the deceased Kailas Meher or on him, as well as injured Narayan Meher and Niranjan Meher. And after hearing the Lennon Council for the state, I am inclined to release the appellant on bail allowed.
Obliged, my lord.
Item
May I please, yours? No appearance memo filed by Mr. Mrs. Sarath Kumar Jana.
Just now I'm filing Millard.
Okay.
Here in this case, Millard, informant is the one of the co-accused, Millard. Very big.
Informant is the
One
wife
of
of
the
the
co-accused.
deceased.
Case is like this, Millard. Initially, on the basis of report filed by the wife of the deceased, UD case was registered, Millard. Subsequently, during course of investigation, it came to that the wife of the deceased and the present appellant has a plan to eliminate the deceased, Millard.
Okay.
Accordingly, Millard, appellant call over the telephone to the wife of the deceased, and as per CDR report, frequently call was made between them, Millard, wife of the deceased and the present appellant, Millard. Last in theory is there also, and some of the material witness, Millard, has not yet been examined, Millard. And a day beginning incident, Millard, they have tried to destroy the evidence of the prosecution, Millard, My
No,
lord,
you are also facing trial.
No, my lord, trial just commenced, my lord.
It's all right. You are also facing trial. So there is no eyewitness to the occurrence.
No, eyewitness.
So what is the circumstantial
I
evidence?
I am appearing, my lord, on behalf of the victim, my lord, sister of the deceased, my lord. Not informant.
Not the informant.
Informant here, my lord, one of the co-accused, my lord.
Wakalatnama. Mr. Sarat Kumar Jena, Land Council files power for one Mommy Das, who is stated to be the sister of the informant.
Sister of the deceased, my lord.
Sister of the deceased. The Wakalatnama is taken on record. Yes, Mr. Tripathi.
Yes, my lord.
What are the circumstantial evidence? You said that there are no.
Is the 164 statement last in theory.
Just a minute. What is the date of custody?
My lord, custody 23/3/23, my lord. Occurrence on 21/1/2023.
What are the offences under which charge is submitted?
Initially, UD case 1 up to 23 registered on the instance of the informant, that is the wife of the deceased, on 29/1/23, my lord. Thereafter, during investigation, the present FIR was registered on 23/3 or 23, and the petitioner was arrested in the same day. On the basis of conventional state of
No. Tell me, what are the offences under which charge is submitted?
Charge sheet submitted under section
302.
Yes.
120B. 201. 34. 32B of SC/ST Act.
So no direct evidence, right?
No.
On the basis of the present petitioner and the deceased are well known to each other, as the present petitioner is the owner of the tractor and deceased driving the tractor of the present petitioner, my lord. And they are regular visit term between the two family. And my lord, the case is that the present.
What is the petitioner is the driver of the tractor?
Petitioner is the owner of the tractor.
Petitioner is the owner.
And
Okay.
this is the working as a driver in the tractor of the present petitioner.
Yes.
And the date of occurrence, it is he went to witness a yajna, and the next day found dead in a well, my lord.
Who?
The deceased.
Okay.
That well is the field of the present petitioner, where there is cultivation is going on. And after the statement of the co-accused, the present petitioner was entangled. Thereafter, the confessional state of the present petitioner.
How he killed the deceased as per his statement?
Statement that he already in drunken state, there is a torture to the wife of the deceased, my lord. And thereafter, they say that there is a relation between the present petitioner and the wife of the deceased, my lord.
Yes.
And the present petitioner pulled the deceased, pushed the deceased into the well, my lord.
There is 15 number of injury, my lord. ପଥରରେ ଛେଚିକିରି କୂଅରେ ଫୋପାଡ଼ି ଦେଲେ.
No, that is the confessional statement of the. Apart from that,
last in theory also.
Who has stated last in?
Lord, that
One Haladhara Das.
What he has stated?
Stated ଜାନୁଆରୀ ମାସ 28 ତାରିଖ ସନ୍ଧ୍ୟା 7ଟାରୁ 8ଟା ଭିତରେ ମୁଁ ଗାଁ ମାର୍କେଟରୁ ପରିବା କିଣି ଘରକୁ ଫେରୁଥିବା ବେଳେ ଗାଁର ତ୍ରିନାଥ ମଣ୍ଡପ ଛକରେ
ଆପଣ date of occurrence is 21/3 ପୁରା?
Yes, that is ଲେଖା ହେଇଛି.
So that is 21/3.
Yes. ପଙ୍କଜ ଜେନା ଓ ଗରିବ ଦାସ ଏକାଠି ମିଶି ପଦର ଆଡେ ଯାଉଥିବାର ଦେଖିଲି. ତା ପରଦିନ ଶୁଣିଲି ଗରିବ ଦାସ ପଦର ଭିତରେ ଥିବା ଗୋଟେ କୂଅରେ ମରି ପଡିଛି.
Name of the deceased is?
ଗରିବ ଦାସ.
ଗରିବ. ଆଉ ଥରେ ପଢିଲେ କଣ ହେଲା? ଦି ଜଣ ଯାକ କୁଆଡେ ଯାଉଥିଲେ?
ପଦର ଆଡେ ଯାଉଥିଲେ. ତା ପରଦିନ ଶୁଣିଲି ଗରିବ ଦାସ ପଦର ଭିତରେ ଥିବା ଏକ କୂଅରେ ମରି ପଡିଛି।
Number of villagers are said, my lord. Namely, Boiragi Das, then my lord Haladhara Das. Number of villagers
No,
are said.
they have seen the
both
two
have
petitioners going.
both appellant and a deceased were going to paddy field, my lord. And there is, my lord, see, as per CDR report, there is frequently telephonic call between wife of the deceased and the appellant, my lord. As per CDR report, my lord, has a plan to.
No, if the confessional statement is that he pushed the deceased into the well, that means he had not assaulted the deceased, just pushed it.
Initially,
ତା ପରଟା କହୁଛି ସେ ଅଧା ପଡିକି ରହିଗଲେ
prior to assaulted by means of stone.
No, he said simply
ତାପରେ
pushed
ମୁଁ
it.
ଜୋରରେ ଗୋଟେ ଧକ୍କା ମାରି କୂଅ ଭିତରକୁ ପେଲି ଦେଲି, କିନ୍ତୁ କୂଅରେ ଉପରେ ଥିବା ପଥରରେ ମାଡ଼ ହୋଇ କୂଅ ଭିତରେ ଥିବା କାଠ ମେଢାରେ ତା ପିନ୍ଧିଥିବା ସାର୍ଟରେ ଲାଗିଯିବାରୁ ସେ ପାଣିରେ ନ ପଡି ଓହଳିକି ରହିଲା। ସେ କୂଅର ଦୁଇ ପଟକୁ ମଧ୍ୟ ଗୋଡ ଦେଇ ରହିଗଲା। ତା ପ୍ୟାଣ୍ଟ ପକେଟରୁ ମୋବାଇଲ ବାହାର କରି ତା ସ୍ତ୍ରୀକୁ ଫୋନ ଲଗାଇଲା ଯେ ଭାଇନା ମତେ କୂଅ ଭିତରକୁ ପେଲି ଦେଇଛି, ମତେ ରକ୍ଷା କର। ଏତିକି କଥା ହେବା ଭିତରେ କୂଅ ଉପରେ ଥିବା ମେଢାଟି ଭାଙ୍ଗି ଯିବାରୁ ତା ମୋବାଇଲଟି ପାଣିରେ ପଡିଗଲା, ସେ ମଧ୍ୟ ପାଣିରେ ପଡିଗଲା। ଆମେ ଆଗରୁ ତାକୁ ମାରିବୁ ବୋଲି ପ୍ଲାନ୍ କରିଥିବାରୁ ମୁଁ ସେଇ କୂଅ ପାଖରେ ଥିବା ପଥରରୁ ଗୋଟିଏ ଛୋଟ ପଥର ତାପରେ ଆଉ ଗୋଟେ ବଡ ପଥରକୁ ଟେକି ଗରିବର ମୁଣ୍ଡ ଉପରେ ପକାଇ ଦେବାରୁ ଗରିବର ମୁଣ୍ଡ ପ୍ରବଳ ରକ୍ତ ବାହାରିଲା। ମୋ ମୋବାଇଲ ଫୋନର ଟର୍ଚ୍ଚ ଲାଇଟରେ ମୁଁ ଦେଖୁଥାଏ। ସେଇ ସମୟରେ ସେମିତି ପାଣିରେ ରହି କୂଅ ଭିତରେ ପଟ ମାଟିକୁ ଧରିବାକୁ ଚେଷ୍ଟା କରୁଥିଲା। ଏହି ସମୟରେ ଗରିବର ସ୍ତ୍ରୀ ଓ ମୁଁ ଫୋନରେ କଥା ହୋଇ କାଳେ ବଞ୍ଚିଯିବ ଓ ଯଦି ବଞ୍ଚିଯିବ ତ ଆମକୁ ମାରିଦେବ ବୋଲି ଭାବି ମୁଁ ରାତିରେ ସେଇଠି ଜଗିକି ରହିଲି। ରାତି ପ୍ରାୟ 3ଟା ପରେ ଗରିବ ପୁରା ପାଣି ଭିତରେ ବୁଡିଗଲା। ତାପରେ ମୁଁ ବାଲୁଗାଁ ପଳେଇ ଆଇଲି।
No, how the dead body was detected? Who found the dead body? Because you said that the occurrence took place on 21/3.
Yes.
2023, and this man was taken into custody on 23/3/2023. So if nobody has seen the appellant assaulting the deceased and it is only his confessional statement, then how the dead body was found in that well, who saw it, and what further you found from the well?
During course, your lordship, during course of investigation, wife of the deceased Manila police ପାଖରେ ଯେ ଆମେ ତାକୁ କୂଅରେ ପକେଇଛୁ ମାରିକି।
Okay. So at the instance of that, what is the recovery part? That dead body was recovered from the well.
Yes.
So what is that seizure list? See that how the circumstances of seizure, how the dead body was recovered, on the basis of whose statement the dead body was recovered.
Dead body recovered next day, but they seized the stone after 2 months. And the last scene is on 21, but after arrest on 23, the statement recorded after 2 months.
No, 21/3/2023, you said the date of occurrence.
28/1 occurrence.
Date of occurrence is
28/1.
29/1.
Okay, that UT case next date the 29.
No, so the occurrence took place on 28/1/2023.
No, 21, 28.
28.
28.
28 January 2023, right?
Yes.
Then UD case was
next date.
Next date means 29. Then FIR was lost
23/3. 2023.
Thereafter, this man was taken into custody. During course of UD case inquiry, that means that dead body was recovered from the
recovered that written that 28 at the night at about 10 p.m. Her husband had been village Belpart to see Jogya, but did not return to the house. They searched for her husband, and in the morning about 7 a.m. they noticed her husband in dead condition inside the well in situated Dalamakal.
So now, except this confessional statement and this last scene you said by some.
Yes.
My lords is right, but Lord, initially, my lord, the wife of the deceased and the appellant trying to destroy the prosecution evidence, my lord, knowingly gave a report, my lord, ଯେ ଯଜ୍ଞ ଦେଖିବାକୁ ଯାଇଥିଲେ ଆଉ ଆମେ ପାଉନୁ ମିସିଂ ରିପୋର୍ଟ ଦେଇକିରି ୟୁଡି କେସ୍ କଲେ So it is, my lord, from the face of the record, it shows that, my lord, intention of the my prayer, limited prayer, my lord, after examination some material witness, my lord, otherwise
The material witness means the
villagers mane
witnesses last seen.
Again.
And CDR report is there.
CDR
That is frequently called between the two accused persons.
This is the whole, my lord, can.
Are the land counsel for the petitioner, land counsel for the state, land counsel for the victim, the sister of the deceased, right?
Sister.
The land counsel for the appellant submitted that the occurrence in question took place on 28/1/2023, and the deceased Garib Das was found missing. This is na Garib Das to?
Yes.
Garib Das was found missing, for which missing report was given in the police station. Beguniapada police station. And when UD case was registered, during UD case inquiry, the dead body of the deceased was found from a well. And postmortem was conducted. And it was found that the deceased has sustained number of injuries.
15 number of injuries.
Number of injuries. However, SI of police Beguniapada police station on his own information lodged the FIR before the IAC Beguniapada police station on 23/3/2023 against the appellant as well as the widow of the deceased, namely Sudeshna Das. Land Council further submits that there are no eyewitnesses to the occurrence and the case is based on circumstantial evidence. And the main circumstance is the last scene of the deceased in the company of the petitioner. and therefore the bail application of the petitioner may be favorably considered. And charge sheet has been submitted under section 302, 120B, 201 with 34 of the Indian Penal Code, section 32B of the SC/ST Act. And in view of the nature of accusation, the bail application may be favorably considered. Learned counsel for the state, on the other hand, oppose the prayer for bail and submits that though Sudeshna Das, the widow of the deceased, informed the police at the first instance about the missing of her husband, Gariba Das, but during course of inquiry, it was found that she is also involved in the commission of murder of her husband. And she was in regular contact with the present appellant, for which FIR was lodged against her also. The Land Council for the state submitted that CDR call details indicates about the frequent contacts made between the appellant as well as the widow of the deceased. And the manner in which the crime has been committed, it is not a case for grant of bail. The Learned Counsel appearing for the victim also opposed the prayer for bail and contended that the appellant was the owner of a tractor and the deceased was the driver of the said tractor, and the deceased was pushed into the well and assaulted, and as per the post-mortem report, there are 15 injuries sustained by the deceased. And at this stage, if the appellant is released on bail, there is likelihood of tampering with the evidence. Considering the submission made by the Learned Counsel for the respective parties, nature of accusation against the petitioner, even though the case is based on circumstantial evidence, but the manner in which the crime has been committed and chance of tampering with the evidence at this stage, I'm not inclined to release the petitioner on bail. The Learned Trial Court shall do well to expedite the trial and at the first instance take steps for examination of all the witnesses to the last seen theory. The petitioner is at liberty to renew the prayer for bail after examination of such witnesses.
Publish.
Item 36.
Yes, what modification you want, Mr. Mishra?
My lord, Lordship has been pleased to grant bail to the petitioner on 9/5/2023.
Yes.
and the offences are 420, 294 and 506 reduced section 3 of the SC/ST Act. And Lordship impose a condition of depositing. Lordship may kindly peruse the order, my lord, of my lordships. 9/5/2023 order.
Appellant shall furnish
My lord,
50% of the cheating amount as cash security.
Cash security learned code below at the time of release of bail, and so far as the balance amount is concerned, he shall give an undertaking before the court to deposit the same in 5 equal monthly installments. Till date, my lord, that 50% the petitioner is not able to arrange.
But perhaps you took instruction and said that he
My
is
lord.
able. He has not yet been released.
No, my lord, he is in custody till date. 2 months already, more than 2 months elapsed, and he is inside custody from his date of arrest, my lord.
So 3,14,000, how much he can deposit at present? Tell me on instruction, because if you want to reduce, then he has to pay the balance. So how much he is now ready to pay? 50% mean it comes to 1 lakh around
1,57,000.
57,000, right? So how much he is now ready to deposit?
50,000 2 months ଅଧିକା ରହିଗଲା.
Here, Mr. Tripathi
Yes, sir.
is released on bail but unable to furnish that cash surety.
Arrest amount to be
that
equal.
obviously that will
Arrest amount
heard the Learned Council IA number so and so. There is an application for modification of the order dated so and so. The Learned Council for the petitioner submitted that while directing the petitioner to be released on bail as per the order dated 9/5/2023, taking into account that cheating amount is rupees 3,14,000. This court directed the appellant to furnish cash surety of 50% of the cheating amount before the Learned Court below at the time of release on bail, and the balance amount. For the balance amount, he has to give an undertaking before the court to deposit the same in 5 equal monthly installments, and the deposit of the first installment shall commence a month after his release on bail. The Land Council further submits that the petitioner is unable to furnish cash security of 50% of the cheating amount, and therefore, in spite of the passage of 2 months' time, in the meantime, he is not able to come out of jail custody. And therefore, the amount of deposit of cash security be reduced. When a query is made to the Land Council for the petitioner as to what amount the petitioner is ready and willing to deposit at this moment, Mr. fairly submitted that petitioner appellant is ready to deposit rupees 50,000. Land Council for the state has no serious objection for the modification of the condition, considering the submission made by the Land Council for the respective parties. The order dated 9/5/2023 is modified to the extent that the petitioner shall furnish cash security of rupees 50,000 before the Learned Court below at the time of his release on bail, and so far as balance amount is concerned, he shall give an undertaking before the court to deposit the same in 5 equal monthly installments, and the deposit of the first installment shall commence a month after his release on bail. Rest part of the order remains unaltered. IA is disposed of.
Obliged.
37.
Yes, Mr. What is this application for condonation of delay? What is this criminal appeal for?
Lordship, SC appeal bail, Lordship.
So what is the delay pointed out by the stamp reporter?
Lordship, I filed the IF of the condonation of delay.
No, what is the delay pointed out?
Pointed out the rejection copy ଟା 90 ଦିନରେ କରିବା କଥା ତା ପରେ କରିଥିଲି ସେ
114 days.
Yes, Lord.
So notice has to go.
Yes, Lord. My Lord.
You are appearing for the informant.
My Lord, pursuant to notice I have appeared.
So let the delay be condoned.
My Lord.
Okay. IA number 910 of 2023. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 114 days in filing this criminal appeal after hearing the land counsel for the petitioner, land counsel for the state, as well as land counsel for the informant. And since it's a bail application,
yes,
I'm inclined to condone the delay. Delay is condoned. Yes, you can argue the matter.
The petitioner custody since 4/8/2021, Lordship.
Just a minute. So you have filed 2 bail applications,
Yes,
right?
Lordship. Yes, Lordship.
They are arised out of the one case.
One case.
Okay. So the CRLA number 419 of 23,
Yes,
Vaikuntha Naik,
Vaikuntha Naik.
he is the sole appellant in that case.
Nice, another co-accused person had involved the case.
No. I'm telling you
Yes,
that
Lordship. So like in this bail petition,
criminal appeal, bail
yes,
application, sole appellant.
Yes, Lordship.
And what about the CRLA number 269?
The same.
Jokeshwar Naik, also one appellant.
Yes,
Okay.
Lordship.
So they are in judicial custody since when?
4/8/2021.
One date they were taken
Yes,
into.
Lordship.
So custody is
4/8/2021.
2021. What are the offenses under which charge sheet submitted?
Charge sheet under Lordship 363, 364, 302.
360, just a minute. 363.
364.
Yes.
302.
Yes.
201. 379. 120B. 109. 506. 34 IPC, Lordship.
SC/ST?
SC/ST, Lordship, the kindly see the Annex 2, page 31. 31, Lordship. Manas Das, Mino Ketan Naik, Tulu Behera, Samsudhan Naik, Vaikuntha Naik, Jogeshwar Naik, Sadananda Naik belongs to SC and ST category, Lordship.
Okay, so you are not charge sheeted under SC/ST Act?
Yes, Lordship.
Okay, what is the name of the deceased?
Name of the deceased, Lordship, Satyavrata Naik, Lordship.
Date of occurrence?
Date of occurrence took place between 1/8/2021 and 2/8/2021.
Any eyewitnesses?
Eyewitness, Lordship, no eyewitness. The 161 of the statement of the informant as well as the brother of the deceased. At page 37, Lordship. The brother of the deceased, Anand Naik, as stated as per the allegation of the petition 36 started 36.
Okay.
The relevant person, Lordship, 37, Lordship.
Yes.
Lordship. Punarbar 8 ঘন্টা সময়.
No, which line you are replacing?
Lordship, 37.
37, which line?
Line.
From the top, what is the line you are placing?
Lordship, 19 or 19.
Yes, read out.
ପୁନର୍ବାର ପ୍ରାୟ ସନ୍ଧ୍ୟା 8 ସମୟରେ ସତୁଆ ଛକରେ ଭାଇ ସତ୍ୟବ୍ରତକୁ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ଟୁଲୁ ନାୟକ ବେହେରା ବେଠି କଥାବାର୍ତ୍ତା କରିଥିଲେ ଏବଂ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ଟୁଲୁ
just go slowly.
Yes, Lordship.
ସନ୍ଧ୍ୟା 8ଟା ସମୟରେ
ଛତୁଆ ଛକରେ
ଭାଇ ସତ୍ୟବ୍ରତଙ୍କୁ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ଓ ଟୁଲୁ ବେହେରା
Satyavrata means this deceased.
ଡିସିସ୍ ଲର୍ଡସିପ୍ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ଓ ଟୁଲୁ ବେହେରା ଭେଟି କଥାବାର୍ତ୍ତା କରିଥିଲେ ଓ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ଓ ଟୁଲୁ ବେହେରା ତାଙ୍କୁ ଜବରଦସ୍ତ ଏକ ମୋଟର ସାଇକେଲରେ ବସାଇ ନେଇ ଯାଇଥିବା ବେଳେ ମୁଁ ସନ୍ତୋଷ ନାୟକଙ୍କୁ ଦେଖି ପଚାରିବାରୁ ସେମାନେ ଗୁମ୍ପୁରରେ କାଲି ଏକ ମିଟିଂ ଅଛି କହି ତାକୁ ଜବରଦସ୍ତ ଏକ ମୋଟର ସାଇକେଲରେ ବସାଇ ନେଇ ପଳାଇଥିଲେ।
So the two persons took. One is Swapneshwar Naik and the other is
Tulu Behera.
Tulu Behera. That is not the petitioners
No,
or
no,
appellants. Okay. Then what happened?
ରାତି 11ଟା ପର୍ଯ୍ୟନ୍ତ ସତ୍ୟବ୍ରତ ଘରୁ ନ ଫେରିବାରୁ ମୁଁ ତାଙ୍କ ମୋବାଇଲ ନମ୍ବର ସୁବାଂଶ ମୁଁ ଫୋନ କରିବାରେ ଫୋନ ସୁଇଚ ଅଫ୍ ଦେଖାଇଲା। ଭାଇ ଲର୍ଡସିପ ଦ ବ୍ରଦର ଅଫ ଦ ଡିସିଜ୍ ଭାଇ ଫୋନ ନ ଉଠାଇବାରୁ ଆମ ଘର ଲୋକ ଭୟଭୀତ ହୋଇଯାଇଥିଲେ ଓ ଆଖପାଖ ଗାଁରେ ଖୋଜିବାରେ ଭାଇଙ୍କ ଖବର ମିଳି ନଥିଲା। ତାପରେ ଦିନ ଅର୍ଥାତ୍ 2/8/21 ସକାଳ 10ଟା ସମୟରେ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ଏକ ହିରୋ ହୋଣ୍ଡା ମୋଟର ସାଇକେଲରେ ଆସି ମୋ ପୁତୁରା ବସନ୍ତ ନାୟକଙ୍କୁ କରଡ଼ଗାଡ଼ିଆ ଗାଁ ଆଦିବାସୀ ସାହି କାଜୁ ଜଙ୍ଗଲ ମଶାଣିରେ ଡାକି ନେଇ ଯାଇଥିଲେ। ବସନ୍ତ ମଶାଣିରେ ପହଞ୍ଚି ଦେଖିଲା ତା ଭାଇ ସତ୍ୟବ୍ରତଙ୍କ ପିଠି ହାତରୁ ରକ୍ତ ବାହାରୁଥିଲା। ତାଙ୍କୁ ଏକ ଜୁଇରେ ଲଦା ଯାଇଥିଲା। ଭାଇଙ୍କ ମୁହଁକୁ ଦେଖି ବସନ୍ତ ବୋଲି ଚିହ୍ନିଥିଲେ। ସେହି ଜୁଇ ପାଖରେ ସପନା ନାୟକ ବସନ୍ତକୁ କହିଲା, ତୋ ଦାଦାଙ୍କ କାଲି ହାର୍ଟ ଆଟାକରେ ମୃତ୍ୟୁ ହୋଇଥିଲା, ତେଣୁ ତୁ ମୁଖାଗ୍ନି ଦେ। ବସନ୍ତ ମୁଖାଗ୍ନି ଦେବାକୁ ଅରାଜି ହେବାରୁ ମଶାଣିରେ ଉପସ୍ଥିତ ଥିବା ସପନା ନାୟକ, କରଡ଼ଗାଡ଼ିଆର ଟୁଲୁ ବେହେରା, ଖୋର୍ଦ୍ଧା ହଳଦୀପଡ଼ା ଗ୍ରାମର ବିଜୟ ନାୟକ, ନିମାପଡ଼ାର ତାତଳମାଳ ଗ୍ରାମର ଶ୍ୟାମଘନ ନାୟକ, ପିପିଲି ଶମଶୁର ଜୁଣୁପଡ଼ିଆ ଗ୍ରାମର ବୈକୁଣ୍ଠ ନାୟକ, ଦିସ୍ ପିଟିସନ୍ ଲର୍ଡସିପ୍ ବୈକୁଣ୍ଠ ନାୟକ,
Vaikuntha Naik.
ବୈକୁଣ୍ଠ ନାୟକ,
Yes.
ତାଲଚେର ବାଲିଗଡ଼ ଯୋଗେଶ୍ୱର ନାୟକ, ଆନାଦର
Okay.
ତାଳତୁମ୍ବ ଗ୍ରାମର ମିନକେତନ ନାୟକ, ବନ୍ତଳା ଥାନା ଜାମୁଣ୍ଡା ଗ୍ରାମର ସଦାନନ୍ଦ ନାୟକ ପ୍ରଭୃତି ଉପସ୍ଥିତ ରହି ଭାଇ ସତ୍ୟବ୍ରତର ଶବକୁ କାଠ ବାଉଁଶ ଟାୟାର ଜାଳି ପୋଡ଼ି ଦେଉଥିଲେ। That is the allegation of the petitioner. And the assault party is concerned that Tulu Behera and Swapneshwara Naik assaulted the deceased.
Where from you got it?
That's it.
Where from you got it if there are no eyewitness to the occurrence?
Eyewitness even he देखते
Who has stated? He has not stated to have seen any assault.
No, assault party is concerned another co-accused. Swapneshwar Naik and Tulu Behera assaulted the deceased and took a.
No. Where from you got that the co-accused persons assaulted the deceased? Whether it is accused statement, confessional statement.
36 page
36 page.
And FIR be lordship.
36. You took me straight to page number 37.
Yes, Lord.
So wherein it is mentioned that at about 8 o'clock in the evening, the deceased was taken by two persons. One is Swapneshwar Naik, the other is Tulu Behera.
The prior the dead, so co-accused person Tulu Behera and Swapneshwar assaulted.
Where is that? Where is that portion? Page 36.
37 ri achi
Please show that portion.
No, lordship, page 37.
Ninth line from the top.
Yes, lordship.
1, 2, 3, 4, 5, 6, 7, 8, 9. Swapneshwar Saitya Swanso ପ୍ରଭୃତି ମିଶ୍ରଣରେ ସଭାରେ ଯୋଗ ଦେଇଥିଲେ। Where is that? ଆଚ୍ଛା
4 ଲାଇନରେ ଅଛି। ସେଥିପାଇଁ ମୋର ଗତ 1/8/2021 ଦିନ ମାନସ ଦାସ ଓ ବେଲେଶ୍ୱର ପରିଡ଼ାଙ୍କ ମିଶ୍ରଣ ସଭାର ଆୟୋଜନ ଆମ ଗାଁ ଅଭିମାନପୁର ସପନା ଘର ପାଖରେ ଥିବା କୋଠା ଘରେ ମାନସ ଦାସ, ତାର ଲୋକ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ, ଟୁଲୁ ବେହେରା ଓ ମିନକେତନ ନାୟକଙ୍କ ମାଧ୍ୟମରେ କରିଥିଲା। ଏହି ସଭାରେ ଆମ ଗାଁରୁ ମୁଁ, ଛବି ନାୟକ, ସନ୍ତୋଷ ନାୟକ ଓ ଅନ୍ୟାନ୍ୟ କେତେ ପିଲା ଯୋଗ ଦେଇଥିଲୁ। ସେହି ସଭାରେ ଗୋଟିଏ ବ୍ୟାନର ମାରିଥିଲେ ଯେଉଁଥିରେ ମାନସ ଦାସ
ଭାଇ ଏହି ସଭାରେ ଯୋଗ ଦେଇ ନଥିଲେ। ଲୋକ ପଠାଇ ସେହି ସଭାକୁ 10ଟାରେ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ମୋର ଭାଇ ସତ୍ୟବ୍ରତକୁ ଡକାଇଥିଲା। ସେଠାରେ ଭାଇ ପହଞ୍ଚିବା ପରେ ତାକୁ କୋଠାଘରେ ଚାଲିଥିବା ମିଟିଂ ରେ ତାକୁ ଆଣ୍ଠୁ ତଳେ ଗୋଡି ଦେଇ ଆଣ୍ଠେଇ ଦେଇଥିଲେ। ଦେନ୍ ସୋ ଆଣ୍ଡ ସୋ କହି ସଂଗଠନରେ କାହିଁକି ମିଶାଇଲୋନି କହି ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ, ମୀନକେତନ ଓ ଟୁଲୁ ବେହେରା ସେଠାରେ ମାଡ଼ ଦେଇଥିଲେ। ମାଡ଼ ଦେଲା ସମୟରେ ସୋ ଆଣ୍ଡ ସୋ
Minoketan lordship granted lordship bail lordship. One CLN
What is the number of that?
147 by 23 lordship.
147 of
23 lordship.
Have you got the copy of
Yes,
that order?
yes, lordship.
Pass on. So, Mr. Tripathi,
Yes, sir.
if that Minoketana has been released on bail, then this man stands on the similar footing because this man had not taken the deceased, only Swapneshwar and Bulu had
Bulu, sir.
taken. And whatever has happened in the cremation ground,
Yes, sir.
that may at best make out a case under 201 IPC. What is your submission?
My lord, page 30 of the charge sheet, my lord, third para, my lord. During investigation of the case, initial IIC Begunia Page visited the spot, examined the complainant and other witnesses and recorded their statement under section 161 of CRPC. Further, the accused Swapneshwar Naik, Tuire Boykunda Naik, the present petitioner, Tulu Behera, and Shyamaghana Naik, Jogeshwara Naik, another connected case. 6 Vijay Naik were arrested and they confessed their guilty in the presence of witness for assaulting the deceased, committing his murder, and to destroy the evidence, cremated his dead body, and led police to witness, identified the spot house, and accused Tulu Behra, that is the place of assault, gave recovery of the weapon of offense, wooden stick, pipe, etc., identified the place of cremation, which were
all right.
videographed by the videographer Milan Parida.
Are the Learned Counsel for the Appellant, Learned Counsel for the State, Learned Counsel for the Informant. The Learned both the matters is to be one order, is to be common order, is to be passed. The Learned Counsel for the appellant submitted that the appellants are in judicial custody since 4/8/2021 and they have been charge sheeted under section 8 this bail order. He further submitted that the occurrence took place in between 1/8/21 and 2/8/2021 and the first information report was lodged on 3/8/2021 and he placed the statement of which statement you are placing that
The brother of the deceased lordship.
What is his name?
Anand.
Page number
36 lordship. Anand Naik.
Okay. Placing the statement of one Ananda Naik, the brother of the deceased, Land Council submitted that it appears that one Swapneshwar Naik, Minoketan Naik, and Tulu Behera assaulted the deceased Satyabrat Naik, and then Swapneshwar Naik and Tulu Behera took away the deceased with them in a motorcycle. The Land Council further submits that from the said statement, it appears that both the appellants were present in the cremation ground where the dead body of the deceased was cremated. And since there is no material that the appellants have assaulted the deceased or forcibly taken him away, the role attributed against the appellants may at best make out an offense under section 201 of the Indian Penal Code, which is bailable in nature. It is further argued that co-accused Minoketan Naik, who allegedly assaulted the deceased prior to his kidnapping, prior to his abduction, has been released on bail by this court in criminal appeal number 147 of 2023 as per order dated 8/5/2023, and therefore the bail application of the petitioner may be favorably considered. Learned counsel for the appellants file the copy of the bail order of the co-accused Minoketan Naik, which is taken on record. Learned counsel for the state oppose the prayer for bail. And however, doesn't dispute that as per the statement of Ananda Naik, the role that has been attributed against the two appellants are regarding cremation of the dead body of the deceased. Learned counsel for the informant also oppose the prayer for bail, considering the submission made by the learned counsel for the respective parties, nature of accusation against the appellant, since the main role has been attributed against co-accused Swapneshwar Naik and Tulu Behra, taking into account the part played by the appellant in the cremation ground and release of the co-accused on bail and period of detention of the petitioner in judicial custody, appellants in judicial custody, I'm inclined to release the appellants on bail allowed.
Obliged.
Yes. Okay. So rest of the case tomorrow because election.
Lordship, item 42 and 47. Lords, I'll supply co-accused order copies to my learned senior for the state for verification. Lords.
It will be taken up tomorrow.
My lords,
Item number 13. IF for change the nomenclature of the case.
Tomorrow, learning council.
ଦେଖନ୍ତୁ ଟିକେ ପ୍ରମୋଦ ବାବୁ ଲାଷ୍ଟ ଏଭିଡେନ୍ସ ଲାଷ୍ଟ ସେଣ୍ଟେନ୍ସ ଟା ଦେଖ ଲାଷ୍ଟ ସେଇଠୁ ଏ ଯୋଉ ଦେଖନ୍ତୁ ପଢି ଦିଅନ୍ତୁ according to article 173A of the Constitution of India,
A person shall not be qualified to be chosen to fill a seat in the legislature of the state unless
is a citizen of India and make and subscribe for people from persons authorizing that behalf by the Election Commission and oath or affirmation according to the form set out for the purpose in the third section. The nomination paper of the respondent in Form 2B under its Part 3 against item A, the respondent has declared that he is a citizen of India and no one has contradicted the statement. The ଉପରେ ପଚାରୁଛନ୍ତି ଦେଖନ୍ତୁ Part 3A ରେ respondent ଲେଖିଛନ୍ତି I, the candidate mentioned Part 1, assent to this nomination and do hereby declare that I am a citizen of India.
Yes. In support of his declaration in his nomination form 2B under its Part 3, item A, that the respondent is a citizen of India, he has submitted Exhibit AZ. Final voter list. Exhibit BC, photocopy of voter I card. Exhibit BD, photocopy of PAN card. Exhibit BE, photocopy of Aadhaar card. In his first set of nomination.
Yes.
Second set of the
Okay.
In support of his declaration in his nomination form 2B under its Part 3, item small a,
In support his declaration, in support of his declaration,
in his nomination form 2B
support of his declaration,
in his nomination form 2 capital B under its Part Roman 3, item small a within bracket, the respondent, that the respondent is a citizen of India he has submitted Exhibit A, capital Z, capital A, capital Z, final voter list.
photocopy of the final of the final.
Exhibit BC, photocopy of voter I card.
Identity card.
Exhibit BD, photocopy of PAN card. Exhibit BE, photocopy of Aadhaar card. In his first set of nomination. Comma.
And enter the copy. In support of his declaration in his nomination in Form 2B under Part 3 against item serial number, item number
Small a.
That the respondent is a citizen of India, comma, he has submitted
He
sworn.
has also submitted.
Copy.
Exhibit BU, photocopy of final voter list. Exhibit BX, photocopy of voter I card. Exhibit BY, photocopy of PAN card. Exhibit BZ, photocopy of Aadhaar card. In his second set of nomination. And Exhibit CK, photocopy of final voter list. Exhibit CN, photocopy of voter I card. Exhibit CP, photocopy of PAN card. Exhibit CQ, photocopy of Aadhaar card in his third set of nomination. And Exhibit DB,
photocopy of final voter list,
photocopy of final. Exhibit DE,
photocopy of voter identity card,
Exhibit DF,
photocopy of PAN card,
Exhibit DG,
photocopy of Aadhaar card in his
fourth set of nomination. Under Article 73 small b, 173 small b, it has been prescribed that a person shall not be qualified to be chosen to fill a seat in the legislature of a state unless he is, in the case of a seat in the legislative assembly, not less than 25 years of age.
Yes.
The respondent, in the instant case, having been completed 25 years of age on the day of filing of his nomination, is qualified to be chosen to fill a seat in the legislative assembly of the state of Odisha. And to that effect, he has made declaration in his nomination form to be under its part 3, item B.
that I have completed 53 years of age.
Under Article 173,
Article 173, bracket B of the Constitution of India provides
A person shall not be
that a person shall not be qualified to be chosen to fill a seat in the legislature of a state unless he is, in the case of a seat in the legislative assembly, not less than 25 years of age. Stop. The respondent has mentioned his age to be 53 years. 53 na sir?
53 sir.
53 years. Kothre mention korche na?
The respondent has mentioned in his nomination paper.
Acha, is in age to be in his nomination paper.
In his nomination paper, in Form 2B,
in Form 2.
under Part 3,
item small b.
Part 3, item small b.
Under Article 173C, therefore, he is qualified to, the respondent is qualified to be chosen to fill a seat in the legislative assembly of the state of Odisha. Under Article 173 small c of Constitution, it has been further prescribed that a person shall not be qualified to be chosen to fill a seat in the legislature of a state unless he possesses such other qualifications as may be prescribed in that behalf by under any law made by the parliament.
What are those?
ସେଇଟା ଆମେ RP Act କୁ ଯିବୁ।
ଆଚ୍ଛା ନାଇଁ ଏଇଟା ତା ସାଙ୍ଗରେ ଲିଙ୍କ ରହୁଛି ତ ଏଇ ଗୋଟେ କ୍ୱେଶ୍ଚିନ୍ ମିଶେଇ ଦେଲେ ବେଟର ହବ। ଅଲରାଇଟ୍ ଆର୍ଟିକଲ 173 ଲେଖନ୍ତୁ ଆର୍ଟିକଲ 173C of the Constitution of India, person shall not be unless he possesses such other qualifications as may be prescribed in that behalf by or under any law made by Parliament. P capital. B. Stop.
Under Article 191, ଦେଖନ୍ତୁ sir. The disqualifications for membership of the Legislative Assembly or Legislative Council have been prescribed. We are concerned with Legislative Assembly only. Under Article 191, 1 small a, it has been prescribed that a person shall be disqualified for being chosen as and for being a member of the Legislative Assembly of a state if he holds any office of profit under the Government of India or the Government of any state specified in the first schedule other than an office declared by the legislature of the state by law not to be disqualify its holder.
Article 191 of the Constitution of India. Bracket 1 कर दें of the Constitution of India. Bracket is small of the Constitution of India provides that a person shall be disqualified for being chosen as, comma, or for being and for being, comma, a member of the Legislative Assembly
of a state.
Legislative Assembly of a state if he holds any office of profit under the Government of India or the Government of any state specified in the first schedule F capital, SB capital, comma, other than an office comma, other than an office declared by the legislature of the state by law approved not to disqualify its holder.
In the instant case, the respondent has made declaration in his nomination paper in Form 2B under its Part 3 capital A within bracket 2 that he is not holding any office of profit under Government of India or state government.
Again. Okay. In his nomination paper, so you can continue, Gaurav. In Form 2B, comma, the respondent has declared that he was not holding.
He is not.
No, he was over that level. He was not holding any office of profit. Copy office of profit under the government or under
under the Government of India or state government.
State basati of any or government of or state government कर दो. Government of India or the state government.
Or state government.
अच्छा दीटा करते हैं. Okay.
Nomination for in Form 2B. के 2B तक मैं रट के जोड़ी दबा under its Part 3A.
अच्छा लिख दूँ under
within bracket 2.
Part 3A against 3 capital A. 8 bracket run one. Against item number
2.
Item number 2 in no person. तापर कमा दिया 2B पर काटी तुम कमा.
Therefore, he is not disqualified to be chosen as a member of the State Legislative Assembly, Orissa, in as much as there is no objection to that effect before you by anybody contradicting that declaration.
Okay. Therefore, the respondent was not disqualified on this ground, and and there was also no objection, from anyone to such declaration, contradicting such declaration made by the respondent.
191 1B की देखें. Under Article 191 1B, it has been prescribed that a person shall be disqualified for being chosen as a member of the Legislative Assembly of a state if he is of unsound mind and stands so declared by a competent court.
Article से पर्यंत आउट क्या गुने setting agent. If 191B करो, 191B करो, तो becomes provides that a person so and so of a state, if he is of unsound mind and stands so declared by a competent court,
shall be disqualified.
Sir, roila bro.
Exact wording there.
In the instant case, to the best of your knowledge, the respondent Muhammad Mukim is not of unsound mind and he has not been so declared by any competent court of law, inasmuch as there is no such objection before you from anybody contradicting the above statement.
To the best of my knowledge and observation, I was of the view that the respondent was not of unsound mind and he was not declared so by any competent court. He was not so declared by any competent court, and moreover, no one raised any issue.
Objection.
Any issue in that respect before me at the time of scrutiny.
Under Article 191 1 Clause C, it has been prescribed that a person shall be disqualified for being chosen as a member of the State Legislative Assembly of a state if he is an undischarged insolvent.
If he is an
Undischarged insolvent.
Undischarged insolvent.
In the instant case, the respondent in his nomination paper in Form 2B under its Part 3A against Item 3 has declared that he has not been declared insolvent by any court of law.
The respondent, continue करूँ तब. The respondent in his nomination paper in Form 2B
under its Part 3A, 2B का capital है. Under its Part 3A, the capital A against item number 3 has declared that he has not been declared insolvent by any court.
and there was no objection to this effect before you by anybody.
And moreover, ସେଇଟା copy କରିଦେଇ paste କରିଦିଅନ୍ତୁ। ହଁ ସେ ଯୋଉଟା he has ଜାଗାରେ hard କରିଦିଅନ୍ତୁ। Declared that he had not been that ରହିଲା hard ରହିବ।
Was the written issue or objection? Concept might not be. Or written objection. It has provision of
हाँ
issued of objection.
हाँ हाँ এটা object এটা provision আছে। Yeah, nobody has raised in that respect before at the time of
contradicting the above declaration
made by the respondent. Sir, next.
Under Article 191(1) small d, it has been prescribed that a person shall be disqualified for being chosen as a member of the Legislative Assembly of a state, i.e., if he is not a citizen of India,
ठीक है
comma
Roman 2 or कर दें और तब Roman 2
or
has voluntarily acquired the citizenship of foreign state
of a foreign state, acquired citizenship of a foreign state,
or III, he is under any acknowledgement of allegiance or adherence to a foreign state.
in acknowledgement of allegiance.
ALLEGIANC.
For adherence. To a foreign state.
In the instant case, the respondent in his nomination paper form 2B under its part 3 against item number small a has declared that he is a citizen of India and he has not acquired the citizenship of any foreign state.
I am a citizen of India and have not acquired the citizenship of a foreign state.
And the respondent further declared in his nomination paper form 2B under its part 3 capital A against its item number 4 that he is not under allegiance or adherence to any foreign country inasmuch as there was no objection to the above effect before you or anybody at the time of scrutiny.
The respondent in his nomination paper informed to be अच्छा
against item number A, small a, 3.
At 3 right.
Against it, item number small a has declared that he is a citizen of India and he has not acquired the citizenship of any foreign state.
नहीं जान कॉपी करी पेस्ट करने हाँ पूरा नहीं जान
Foreign state and under part 3A, the capital A, against item number 4 has further declared that he is not under allegiance or adherence to any foreign country.
To any
foreign country.
To any कर दियो to any
अच्छा
ठीक है
Under Article 191(1) small e, it has been prescribed.
अच्छा हाँ no one से जो copy था last one हाँ one more हाँ
and
लगी तो बस
and moreover Kuduran raising objection in that respect before me at the time of scrutiny contradicting the above declarations made by the respondent.
Sir, next.
Under Article 191(1) small e, it has been prescribed that a person shall be disqualified for being chosen as a member of the Legislative Assembly of a state if he is so disqualified by or under any law made by the Parliament. 173B रे जहाँ अच्छी है
For being a member of so if he is so disqualified by or under any law made by Parliament.
Constitutional provision, sorry. Now we will go to the RPR. Paragraph 56.
Sir.
Under Part 2 of the RP Act 1951.
Side would have someone knows it. Okay, sir.
Again. Under Part 2 of the RP Act 1951, under its Chapter 2.
Just sir. Sure.
Again. Under Part 2 of the RP Act 1951, under its Chapter 2, qualifications for membership of state legislatures has been prescribed. Bartan 5 section 5 small a को आसन.
Chapter 2.
Again.
Under Part 2.
कोटा को जिन कितने पेज के से बॉयटा को
Section 5 रो ऊपर देखो.
Section 5.
Heading का देखो. Section 5 रो capital letter अच्छी Chapter 2. That Chapter 2 comes under Part 2.
Qualification ठीक है.
Part 2 का पूरा देखते हैं. Section 3 ऊपर रोज Chapter 1 तापर Chapter 2 qualification and disqualification. Under Part 2.
Sharpocham.
Under Section 5A prescribes 1. A person shall not be qualified to be chosen to fill a seat in the Legislative Assembly of a state unless I, in the case of a seat reserved for SCs or for the STs of that state, he is a member of any of those castes or those tribes as the case may be.
Again.
II is an elector of any assembly constituency in that state. In the instant case, that is 90 Baravati assembly constituency is a general seat and not reserved for SCs or STs.
Okay. Yes. All right. Section 5 of bracket A of the RP Act 1951 prescribes that a person shall not be qualified to be chosen to fill a seat in the Legislative Assembly of a state unless in the case of a seat reserved for the scheduled castes or for the scheduled tribes of that state, Roman 1, he is a member of any other caste.
He is a member of those castes.
He is a member of
member of any of those castes.
Any of those castes or of those tribes.
Or for of such type.
Or for
of
those tribes.
Comma, as the case.
Comma, as the case may be. So,
And
Roman 2. And he's an elector for any assembly constituency in that state.
Eta capital, Sita ছোট।
Stop.
In the instant case, 90 Varavati Assembly constituency is a general seat and not reserved for SCs or STs.
In the case in hand, for them, comma 90 hyphen Varavati, comma Cuttack Assembly constituency is a general seat and not reserved for any SC or ST. Stop. Okay.
The respondent Muhammad Mukim is an elector of 90 Varavati Assembly constituency and under its part 70 at serial number 1112, the photograph and name of respondent Muhammad Mukim appears. Exhibit which has been marked as Exhibit AZ, Exhibit BU, Exhibit CK, and Exhibit DB, and in the nomination paper in Form 2B of the respondent under its Part 1, it has been mentioned that the respondent is an elector of 90 Varavati Assembly constituency and his name is entered in Part 70, serial number 1112. Okay.
Sir,
the respondent, Muhammad Mukim, is an elector of 90 Varavati Assembly constituency and under its part number 70 at serial number 1112, the photograph and name of respondent Muhammad Mukim appears, which has been marked as Exhibit AZ, Exhibit BU, Exhibit CK, and Exhibit DB, and in the nomination paper in Form 2B,
and in his nomination. And in his nomination.
Form 2B of the respondent under its Part 1, it has been mentioned that the respondent is an elector of 90 Varavati Assembly constituency and his name is entered in Part 70, serial number 1112. Section 5.
And it was constituency for and it under its part 70 lecture. Part 70 to lecture. Last but one line now. Part 70 could go its under its.
Section 5C of the RP Act 1951
is not relevant for
under Section 5C of the RP Act 1951, it has been prescribed that a person shall not be qualified to be chosen to fill a seat if the Legislative Assembly of a state, in the Legislative Assembly of a state, unless in case of any other seat, he is an elector for any assembly constituency in that state.
हाँ 5C ठीक है prescribe that a person shall not be so and so unless in the
case of
in
any
the
other seat,
any other seat, comma, he is an elector for any assembly constituency in that state.
In the instant case, the respondent Mohammad Mukim is an elector of 90 Baravati Kotak Assembly constituency.
Sir, जाइए तो सेट सीट वो रखियो सर आउट के पूर्व हाँ सीट हुई
SC और ST पर हाँ
सीट उठा नहीं जाता
As such, he is qualified to be chosen to fill a seat in the Legislative Assembly of the state of Orissa.
Therefore, he is qualified. Therefore, he is qualified. Therefore, the respondent is qualified to be chosen to fill a seat in the Legislative Assembly of the state of Orissa.
Sir.
Under Part 2, under Chapter 3 of the RP Act 1951, disqualifications for membership of Parliament and state legislature have been prescribed.
Section 7 of Kurkumalot heading. Section
all right, under Chapter 3
of Part 2
of the RP Act 1951, disqualifications for membership of Parliament and state legislatures have been provided. Stop.
Section 8 of the RP Act 1951, subsection 1 and 2 prescribes disqualification on conviction for certain offences have been prescribed.
Section 8 of RP Act 1951 prescribes disqualification.
Section 8 minor specific subsection 1 and 2.
कहीं तो सब रोचे ना
नहीं तापर गुड़ा सब होची
convicted पर सब गुड़ा conviction यही गुड़ा के सब हेले जे कोनोसी तरह conviction हेले जीवो तेणु लिखि दियंतु RP Act prescribes disqualification on conviction
3/4 disqualification हेला परे
on conviction for certain offences. Sir, question.
In the instant case, the respondent Mohammad Mukim in his nomination paper in Form 2B under Part Roman 3 capital A against its item number 1 has declared that he has not been convicted of any offences under subsection 1 or for contravention of any law specified in subsection 2 of section 8 of the RP Act.
Declaration. All right. The respondent.
Nor has been convicted for any other offences for which he has been sentenced to imprisonment for 2 years or more.
Achita? Okay. The respondent has declared
Respondent
in his nomination paper in Form 2B
under Part 3A, under its Part 3A. Against item number 1 has declared that he has not been convicted of any offense bracket S under subsection 1 or for contravention of any law specified in subsection 2 of section 8 of the Representation of the People Act 1951,
RPF,
nor he has been convicted for any other offense bracket S for which he has been sentenced to imprisonment for 2 years or more.
Nor there was any objection from anybody before you to the above effect, contradicting the above declaration made by the respondent.
See, Utani associated जो आगुरु टा no one and moreover.
नहीं 55 paragraph.
हाँ सही बात है.
And
हाँ बस.
Therefore,
and moreover, no one raised any objection in that respect before me at the time, and no one raised any objection in respect of such declaration. In respect of such declaration before me at the time of scrutiny, contradicting the above declaration made by the respondent.
Therefore, respondent Muhammad Mokim is not disqualified for membership of the Legislative Assembly of the state as prescribed under Section 8 of the RP Act 1951.
Therefore, therefore, the respondent is not disqualified.
Clear seat in the Legislative Assembly of the state under Section 8 of the Act.
Under Section 8 of the RP Act. Sir.
Section 8 capital A of the RP Act prescribes disqualifications on the ground of corrupt
practices.
Section 8A capital A hyphen of the RP Act 1951 prescribes disqualification on the ground of corrupt practice. RRU.
Practices.
Sir.
Respondent Muhammad Mokim in his nomination paper in Form 2B under its Part 3A against its item number 5 has declared that he has not been disqualified under Section 8A of the RP Act 1951 by an order of the President.
Yes.
And inasmuch as there was no such objection by anybody before you contradicting the above statement of the respondent.
Yes.
The respondent in his nomination paper in Form 2B under its Part 3A against its item number 5 has declared
that
he has not been disqualified under Section 8, capital A of the RP Act 1951 by an order of the President, nor there was
and moreover
copy
पूर्वटा कॉपी करे पूरा सेट जो लास्ट पड़ मोरोवर तारू and moreover taru and taru सेटू नेक्स्ट नहीं अच्छा रेस्पोंडेंट
ନେଲେ
तापरे सेटू सेटा आउ ता पूर्वर लास्ट सेंटेंस ता सब कथा पर therefore
therefore
is not disqualified to be chosen to fill in the legislation of the state of Odisha under Section 8A of the Act.
Section 9 of the RP Act 1951 prescribes disqualifications for dismissal for corruption or disloyalty.
Section 9 of the RP Act 1951 prescribes disqualification for dismissal for corruption or disloyalty, DIS. Sir.
In the instant case, the respondent in his nomination In the instant case, the respondent Muhammad Mokim in his nomination form 2B under Part 3A at its item number 6 has declared that he was not dismissed for corruption or for disloyalty while holding office under the Government of India or the Government of any state.
Yes, sir.
In the instant case, the respondent in his nomination form 2B under Part 3A, under its Part 3A, against item number 6, has declared that he was not dismissed for corruption or for disloyalty while holding office under the Government of India or the Government of any state.
Of any state. After say you last the sentence minister. Author disqualification and more about that. And
Contradicting the above statement of the respondent.
And moreover, no one raised any objection in that respect before me at the time of contradicting the declarations made by the respondent. Therefore, the respondent is not disqualified, not qualified to be chosen to fill a seat in the legislature of the state of Odisha under Section 9 of the RP. Again.
Section 9, capital A of the RP Act 1951 prescribes disqualification for government contracts, etc.
9 hyphen capital A prescribes disqualification for government contracts, etc., etc. Sir.
In the instant case, the respondent in his nomination paper in Form 2B under its Part 3A against item number 7 has declared that he has not any subsisting contracts with the government either in the individual capacity or by trust or partnership in which the candidate has a share for supply of any goods to that government or for execution of works undertaken by that government.
Yes.
Correct.
In the instant case, সেটু কপি করে পুরানি আসলে অপারেশন করবা চিন্তা the instant case the government in its nomination form to be under its part 3 against item number 7
has declared
that he has not any has not any subsisting contract bracket raise contract with the government either in individual capacity or by trust or partnership in which the candidate has a share for supply of any goods to that government or for execution of works undertaken by that government.
Moreover,
state পর্যন্ত নেই স্টেট পর্যন্ত বাস এ পর্যন্ত না section 9 of the specification for government contract in the instant responding in nomination informed under its part here against item 7 has declared that he has not any substituting contracts the government either in the capacity or by trust or partnership and has a share for supply of goods to that government or for execution of work undertaken by that government. And moreover, no one raised any objections in that respect. For me, at the time of scrutiny, contradicting the above declarations made by the respondent. Therefore, the respondent is not
My
disqualified.
lord, before me at the time of scrutiny, before commencement of scrutiny also, they can also contradiction they ତାଙ୍କ ରହିବ ସେ ବି କରିପାରିବେ ସେମାନେ affidavit ଦେଇପାରିବେ ସେଠି ଗୋଟେ ଜିନିଷ ରହିଲେ
scrutiny whatଟା ଓଳି ଦଉ
ମାନେ ନାଇଁ ନାଇଁ scrutiny ହଉ ମାନେ before and during the time of scrutiny
either before or during.
before ଦେଇପାରିବେ
at the time of before or the before me
before and during
before me ସେଇଠି ଲାଗି ଦିଅନ୍ତୁ before ସେ ତାପରେ before or at the time ସେଠି ଆଉ ଗୋଟେ before ଲଗାନ୍ତୁ before me ପରେ before or at the time of scrutiny contradiction
ସବୁଥିରେ ଯୋଡି ଦବାକୁ
in the respect
ମାଇନରଟା ଆମେ ଯୋଡି ଦବୁ
ପରେ ଦେଖ ଠିକ ଅଛି next
Section 10 of the RP Act 1951 prescribes the disqualifications for office under government company.
Section 10 for office under government company.
In the instant case, the respondent in his nomination paper in Form 2B under its Part 3A against item number 8 has declared that he is not a managing agent or manager.
He is not a managing agent. It is or manager
or secretary of any company.
Item number 8 ରେ ଅଛି ତ item number 8 ରେ ଠିକ ଅଛି ଠିକ
ଆପଣ କଣ ଦେଖିବା ପାଇଁ ଚାହୁଁଛନ୍ତି ଟାଇମ୍ ଦେବେ ଆମେ ପଜ ଦବୁ କିଛି ନାହିଁ
RP Act ର provision
section 10 ଟା
ଆଜ୍ଞା
section 10 of the RP Act ଦେଖି ଦିଅନ୍ତୁ ପଢି ଦିଅନ୍ତୁ ଟିକେ ରହି ଯାନ୍ତୁ
ଆଜ୍ଞା
ସେଟା ଏଇଠି ଡିକ୍ଲାରେସନ ଦେଇଛନ୍ତି नो ବୋଲି କୋଉଟା ଆମେ ରହିଲେ is not a managing agent or manager or secretary of any company managing agent or manager or secretary of any company or corporation
ଯୋଉ ୱାର୍ଡଟା ଅଛି ସେତିକି
ଆଜ୍ଞା ବ୍ରାକେଟ ଆରମ୍ଭ other than a cooperative society
bracket end
ଟିଟା ଛୋଟ ଅଛି ଆଜ୍ଞା in the capital of which the central government or state government has not less than 25% share.
Moreover,
The respondent plan that he is not a managing agent or manager or secretary of any company or corporation or the corporation in the capital of the central government or state government has not less than 25% share. Say to and moreover say to state for the and moreover, no one raised any objection that before me before or it copy at the time of scrutiny contradicting the above declarations made by the respondent. Therefore, the respondent is not disqualified to be chosen to sit in the in section 10.
Section 10.
Now, Prota 9 ରହିଯାଇଛି କି 9
ନାଇଁ 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 9 ଜାଗାରେ 9 ଅଛି ବା ସେଟା 9A କରିଦିଅ 9 ହାଇଫେନ୍ କ୍ୟାପିଟାଲ A.
Section 10A of the RP Act 1951 prescribes disqualifications for failure to lodge account of election expenses.
Section 10 hyphen capital A of the RP Act prescribes disqualification for failure to lodge account of election expenses. Stop. Sir.
In the instant case, the respondent Muhammad Mukim, in his nomination paper in Form 2B under its Part 3A, Item 9, has declared that he has not been disqualified by the Commission under Section 10A of the RP Act 1951.
In the
in the instant case, the last one. Instant case on Part A against item number 9 has declared that he has not been disqualified by the Commission under Section 10A of the RP Act.
Moreover,
pass. And moreover, no one raised any objection of the respect that it takes after 10A.
Yeah.
है ना Exhibit AF देखें See Exhibit AF, which is a public notice of election in Form 1 issued by you on 28/3/19 inviting nominations of candidates for election to 90 Barwati Assembly constituency. Wherein it has been specified that nomination papers are to be delivered to you at the place, that is the office of the sub-collector Kotak Sadar.
ଏଇଟା ଯାଇଛି ବୋଧେ ଆଗରୁ
ଏଇ ଯୋଉ କଣ୍ଟେକ୍ସଟ ରେ ଯୋଉ 9 10 10 ଏ ତାପରେ 31 ହଁ 31 32 33 34
ହଉ ସେଟା ଲେଖି ଦିଅନ୍ତୁ ସେଟା କି
ଏଟା ଲିଙ୍କ Section A, Exhibit AF is a public notice of election in Form 1 issued by you on 28/3/19 2019
issued by me on 28/03/2019
inviting nominations of candidates for election to 90 Barwati Assembly constituency wherein it has been specified that the nomination papers are to be delivered to you at the place that is the office of the sub-collector Kotak Sadar.
Form number 1 issued by me under section 31.
देखी ध्यान चेक कर ध्यान
31. It is complete. Of nomination, public notice 31. Under section 30, the returning officer shall give public notice. Upon the section 30. Under section 31, the RPR. For date for date for data approved by me also. For all. Under section 30.
All the candidates, including respondent Muhammad Mukim, have delivered their respective nomination papers to you, and you have received the same at your office, that is office of the sub-collector Kotak Sadar, during the specified time of filing of nominations, that is from 28/3/2019 to 4/4/2019, both days inclusive in the election in question. All the candidates, including respondent Muhammad Mukim, delivered their respective nomination papers to me, and I received the same at my office, that is office of the sub-collector Kotak Sadar, during the specified period of filing of nomination.
For filing of nomination.
Specified period.
Specified period.
For filing of nominations, that is from 28/3/2019 to 4/4/2019, both days inclusive in the election in question. Section 32 of the RP Act 1951 prescribes that any person may be nominated as a candidate for election to fill a seat if he is qualified to be chosen to fill that seat under the provisions of the Constitution and this Act.
Sappara. Sappara, sir. No,
Section 32 of the RP Act 1951 prescribes that, comma, inverted comma begins, any person may be nominated as a candidate for election to fill a seat if he is qualified to be chosen to fill that seat under the provisions of the Constitution and of this Act. Inverted comma and stop. In the instant case, the respondent. In the instant case, respondent Muhammad Mukim is qualified to be chosen to fill a seat in the Legislative Assembly of the State of Odisha under Article 173, Article 191 of the Constitution of India, and he is also qualified to be chosen to fill a seat in the State Legislative Assembly of the State of Odisha under Section 5, under Section 8, under Section 8A, under Section 9, under Section 9A, under Section 10, and under Section 10A of the RP Act 1951.
The respondent is qualified সেটা কি দিন?
to be chosen
To be chosen
to fill a seat
in the
Legislative Assembly of the State of Odisha. In the State of Odisha.
Under Article 173,
Odisha. Under Article 173
and Article 191
of the Constitution of India,
and
as well as federal.
And is also qualified to be chosen
to fill a seat
in the State Legislative Assembly of the State of Odisha under Section 5, under Section 8, under Section 8A, under Section 9, under Section 9 capital A, under Section 10 and under Section 10A of the RP Act 1951.
Under Section 5 of the Section 8 and Section 8 and Section 9 like under Section 10 and under Section. Thank you.
Sure.
Hello. The respondent Muhammad Mukim is not disqualified to be chosen to fill a seat in the State Legislative Assembly of the State of Odisha under any provisions of the Constitution or RP Act 1951.
the respondent, according to me, the respondent is not disqualified for being chosen to fill a seat in the Legislative Assembly in the state of Odisha, either under the Constitution of India, either under any of the provisions of the Constitution of India or the represent RP Act, or RP Act 1951. Sir.
Section 33 of the RP Act 1951 prescribes provisions for presentation of nomination papers and requirements for a valid nomination.
Section 33 of the RP Act prescribes the procedure.
Prescribes presentation of nomination paper. That's exactly.
Prescribes
for presentation of nomination paper and requirements for a valid nomination.
Requirements for
a valid nomination.
Under subsection 1 of section 33 of the RP Act 1951, it is prescribed as follows.
Subsection 1 तक बुझा जाए requirement
1, 2, 3, 4
सात भागेर सार
Subsection 1 of section 33 of the RP Act 1951 prescribes as follows. Nomination paper shall be presented on or before the date appointed under clause A of section 30. In the instant case, exhibit AE, that is the nomination dated 28/3/2019 of the CEO that is the notification dated 28/3/19 of the CEO and ex officio principal secretary to Government Home Elections Department published in the Odisha Extraordinary Gazette, republishing the notification number 464 dated 28/3/2019 of the Election Commission of India reveals that the last date for making nominations in the election in question is fixed to 4/4/2019. Again.
It's a detailed, the section
Subsection 1 of section 33.
33 bracketed 1 of the RP Act 1951 prescribes that the presentation of nomination paper is to be on or before the date appointed under clause A of section 30, and in this case in hand, the
Exhibit A.
In the case in hand, the last date of presentation of nomination paper,
for making nominations.
last date for making nomination was nominations was 5 was 4/4/2000, and as for exhibit stop A, and in this case the respondent filed his nomination on
All four sets of
nominations on 2/4/2019.
And the first date of filing nomination is 28/3/2009.
Achi, sir. Next.
The respondent Mohammed Mokim has filed his 2. The second requirement under section 33(1) of the RP Act 1951 is that nomination paper shall be delivered either by the candidate or by his proposer. Again.
এটি কি আপন ডেলিভার করছিলা? আচ্ছা, the second requirement as per section 33(1) is that the candidate himself,
nomination paper shall be delivered.
The candidate himself or his proposer can deliver the nomination paper, and in the case in hand, the respondent himself came to my office on 2/4/2019 and delivered 4 sets of his nomination papers,
which would be evident.
Achi to sir, suda achi ho. Not necessary. Yes, sir. Next. Achi to that timing is very much there. Don't make it so meticulous.
Therefore, the respondent Mohammed Mokim has qualified with the second requirement of law.
So next.
Third, the third requirement of law as prescribed under section 33(1) of the RP Act 1951 is that the nomination paper shall be delivered between the hours 11 o'clock in the forenoon and 3 p.m. in the afternoon.
The third requirement as per so and so is that the nomination paper is to be delivered before me as a returning officer between 11 o'clock
between the hours of
between 11 o'clock
11 o'clock in the forenoon and
and
3 o'clock
in the afternoon, and the respondent delivered and the respondent delivered his nomination papers on 2/4/2019 during this time
at 11:20.
at 11:20.
The fourth requirement of law as prescribed under section 33(1) of the RP Act is that every nomination paper shall be delivered to the RO at the place specified in this behalf in the notice issued under section 31 of the RP Act 1951.
The fourth requirement is that every nomination paper is to be delivered
To the returning
to the returning officer at the place specified in this behalf in the notice issued under section 31, and in the case in hand
the specified place is
the specified place was the sub-collector's office,
the office of the sub-collector
the office of the sub-collector ko diyantu, hala, and the respondent
Has complied with the same.
and the respondent has complied with the same. Sir.
The fifth requirement of law prescribed under section 33(1) of the RP Act is that the nomination paper shall be completed in the prescribed form to be.
prescribed form.
Prescribed form likha hai sir.
Prescribed form.
Hmm.
Rule 4 of the conduct of election rules.
The fifth requirement,
Again.
the fifth requirement is that the nomination paper is to be completed
in the
prescribed form. Sir.
Rule 4 go ahead.
Conduct of election rules 1961.
Rule 4 to ତାଙ୍କୁ ଦେଖନ୍ତୁ
ଦେଖିଲି highlight କର
ହେଲା, shall be completed in such one of the forms that is 2A to 2E as may be appropriate.
And
in the instant case, the appropriate nomination form in the election in question is form 2B.
Acha, and rule 4 of conduct of election rules, 19 rules, 1961 prescribes that the nomination paper shall be completed in one of the forms 2A, 2 capital A, hyphen A, 2 hyphen A दियंतु
hyphen और छेद hyphen नहीं
हाँ छेद
फॉर्मेट भी लिखा हुआ
और नहीं 2 TO2 माने सेक्शन ने याद है मु सेक्शन टा कोड करछि तो
ଏଟାରେ ବି ବହିରେ ବି section ରେ ବିଭିନ୍ନ ଫେରେ ବିଭିନ୍ନ
अच्छा 2 एटा काटी दो गुजा अच्छा ठीक है 2 हाइफेन टा काट दियंतु 2A TO2 2E as may be appropriate, and in the instant case the appropriate form is form 2B.
Respondent Muhammad Mukim has filed his 4 sets of nomination papers in form 2B.
कौन कौन देखिए
which is very much available at its top of the each firm, that is Form 2B C Rule 4 nomination paper.
Yes. चारटा जाको देखंतु
चारटा जाको देखंतु
चारटा जाको देखंतु
ଗୋଟେ ସେଟ ଦେଖିଲେ ଏଠି ଦେଖନ୍ତୁ ଫର୍ମ 2B C rule 4 nomination paper third one ଦେଖନ୍ତୁ form 2B C rule 4 nomination paper fourth one ଦେଖନ୍ତୁ form 2B C rule 4 nomination paper again.
Okay, all the 4 sets of nomination papers filed by the respondent on 2/4/2019 by exhibits so and so 39, 40,
41 and 42
were in form 2B. Stop.
Thus, respondent has complied with the 5th requirement of law under section 33(1).
माने सब तो all the requirements कर दे आउ 6th को पढ़े सुन सर.
The 6th requirement of law prescribed under section 33(1) of the Act is that nomination paper shall be signed by the candidate.
The 6th data come, the 5th already golani very. It was the 6th requirement. 6th requirement as per section so and so is that nomination paper shall be papers are ठीक है जी signed by the candidates. Okay. एठी कौन कौन तो पचान तो सर.
and in the pachan
sir pachan.
In all 4 sets of nomination paper, the signature of the candidate Muhammad Mukim appears.
Part 3 तले part 3A तले এবং প্রত্যেক পেজের মধ্যে প্রত্যেক সেটটা
And in all the continue going 4 sets of nomination papers filed by the respondents on 2/4/2019 by सेटा कॉपी करी पेस्ट कर दियंतु से चारटा एग्जिबिट करनी है सो हां बाइट्स वन सो comma he has signed at the appropriate spaces space कर दियंतु नले चलो appropriate space
places that is after part 3 and after part 3A as well as
total कितना signature ଅଛି
on every page of the nomination
as well as on every page of his nomination paper every pages sir.
The 7th requirement of law as prescribed under section 33(1) of the RP Act 1951 is that the nomination paper shall be signed by an elector of the constituency as a proposer.
ठीक तो by signed by an elector of the constituency as proposer एठी अछि
ଏଠି ଦେଖନ୍ତୁ
proposer ଅଛନ୍ତି ତ ଦେଖନ୍ତୁ ସବୁ ଗୁଡା ଚାରଟା ଜାଗାରେ ଅଛନ୍ତି ତ
In the instant case
in the instant case
the candidature of the respondent Muhammad Mukim has been proposed by an elector of 90 Baravati Assembly constituency in part 1 of form 2B in his 4 sets of nomination papers in form 2B.
Candidature of the proposer of the respondent
candidature of the respondent
କରନ୍ତୁ
proposer ଟା ଉଡେଇ ଦେବେ respondent has been
proposed by has been
proposed
by na koyam sir in exhibit number
namely Abhishek Joshi
se kutre sir phone
Abhishek Joshi exhibit bracket photo
Abhishek Joshi
in exhibit 39
in exhibit 39
then
Sheikh Liaqutuddin Ahmad
Sheikh S.K. Bananda Dakuti LIAQUATUDDIN
Ahmad
AHEMET in exhibit 40
Srimati Giribala Behra
in
exhibit 41
and
Ravi Narayana Malik
in exhibit 42
sir
who are the electors of 90 Baravati Assembly constituency. Hala
90 Baravati Kotak Assembly
Hmm.
नाइन्टी जो 12 को लगे दियंतु 90 हाँ फिर 12 को constituency पर full stop दियंतु
Ashok Joshi in exhibit 39 is elected of part number 103 and their names
appear
and their names have been entered names have been entered in the electoral roll in the final electoral
published there entered
in the
electoral roll published
in the electoral in the final
have been published in the
entered
तांको ना गुड़ा कोथरे entered होइछि मन in the final electoral roll at serial number से ये करी कोन
part number
हां कोई
Abhishek Joshi is an elector of 90 Baravati Kotak Assembly constituency.
सर रेस्पेक्टिवली कर दो एका तो खाली नंबर टा कहि दियौ
Abhishek Joshi कर एटा तांकर part number होची कैसेट लेखा इबरा 143
एइटी अछि मो पाखे
अभिषेक जोशी पार्ट नंबर 143
143 then comma
serial number 706 comma
706 comma
तापरे देखंतु शेख लियाकुतुद्दीन अहमद कर 102
8 100 नंबर 102 serial number
857 तापरे
comma
गिरिबाला बेहरा कर
21
serial number 1360 1360
and
part number 152 serial number 376
respectively
Ravi Narayana Malik
respectively
and their names have been entered in the final electoral roll of 90 Baravati constituency
at part number 1
Hala first proviso to subsection 1 of section 33 of the RP Act 1951 prescribes that a candidate not set up by a recognized political party shall not be deemed to be duly nominated for election from a constituency unless the nomination paper is subscribed by 10 proposers being electors of the constituency. ठीक ना?
এটা যাইছি স্যার কোশ্চেন যাইছি
The respondent Muhammad Mokim being set up by Indian National Congress
এটা যাইছি স্যার আপন
এটা भी
पचार दिन हां
Part 2 of Form 2B, that is nomination paper, is required under law to be used by a candidate not set up by a recognized political party.
সেটা যাইছি স্যার।
ନାଇଁ ସେଇଟା ଯାଇଛି କିନ୍ତୁ ଏଇଟା ଏଇ ସିକ୍ୱେନ୍ସ
আচ্ছা হ্যাঁ
ସବୁ ଯାକ ଡିଫେକ୍ଟ ସେ ଦେଖେଇଛନ୍ତି
କପି କରି ନିଅ
কোন স্যার?
ହଁ
First proviso to section 33(1).
ନାଇଁ কোনটা কোଉଟା কি
section টা কই দেই সেটা ছাড়া
কোଉটা কইলে?
First proviso of subsection
কোনটা
1 of section 30.
কোনটা?
Provision that the candidate not set up by recognized party shall not be deemed to be duly nominated. এটা applicable নুহ for the candidate.
ନାଇଁ ଖାଲି କହିଦିଅନ୍ତୁ this is not be applicable ଏତେ ଯାଇଛି already.
Subsection 1 of section 33. Is not section 51 is not applicable for the respondent as he was set up
by a recognized political party.
By a national recognized political party.
Bas, next.
At the top of nomination paper in Form 2B, before its Part 1, there is an instruction in capital letters. Strike off Part 1 or Part 2 below, whichever is not applicable. এটা ମୁଁ ଆଗରୁ ପଚାରିଥିଲି କେବଳ ସିକ୍ୱେନ୍ସ ମେଣ୍ଟେନ କରିବା ପାଇଁ ଏଠି ଆଉଥରେ ପଚାର
ଦେଖ ମତେ ଗୋଟେ
କପି କରି ଆଣିଲେ
ନାଇଁ
ନାଇଁ ସାର୍ ଦେଖନ୍ତୁ
ନାଇଁ ଗୋଟେ ନୋମିନେସନ ପେପର ଗୋଟେ ନୋମିନେସନ ପେପର
ନମିନେସନ ପେପର ଇଟସେଲ୍ଫ ରେ ଅଛି
ସେଟା ପଚାରନ୍ତୁ sir question.
At the top of nomination paper in Form 2B, before its Part 1, there is an instruction in capital letter. Strike off Part 1 or Part 2 below, whichever is not applicable.
All right. There is an instruction in the nomination paper in Form 2B
appearing before Part 1.
Appearing above Part 1, above Part 1, 2, TO2, inverted comma ভিতরে strike off Part 1 or Part 2 below, whichever is not
applicable.
Right, is not applicable, inverted comma says. Sir, Pacharam.
Respondent Muhammad Mokim, having been set up by Indian National Congress.
Part 1 college with the instruction behind. There is also an instruction.
ସେଟା କାଇଁ ଯିବି ତା ପରକୁ ଯିବି ନା ହଁ
এটা যাইছি তো পার্ট 1 টা भी यूज हो बोले
Part 1 টা গলা respondent Muhammad Mokim being set up by Indian National Congress, which is a national recognized political party, is required under law to use Part 1 of Form 2B and to strike off or delete Part 2 of Form 2B. Muhammad Mokim যেহেতু ଗୋଟେ national recognized political party ଦ୍ୱାରା setup ହେଇଥିଲେ, he was required to use Part 1 and not
Part 1 ଟା ଦେଖିଲେ ତ সেটা রହୁଛି ঠিক ଅଛି ତାପରେ ବର୍ତ୍ତମାନ এই ইম্পর্টেন্ট কোশ্চেনটা কোন স্যার ପଚାରୁଛନ୍ତି ଯୋଟା
respondent being set up by a recognized national political party, he is required to use Part 1 and not Part 2.
Yes.
The respondent being a candidate of a national recognized of Form 2B, and accordingly he has done the same.
And to delete Part 2
and
to strike up on delete.
To strike up and delete. Strike up or delete.
To strike off
of Form 2.
Oblique, strike off or delete. Part
2 of Form 2B.
Form 2B. See, part 1 to fill up करछन्ति.
अब part 2 टाक भी delete करछन्ति.
The respondent has filled off part 1 and deleted part 2 of his nomination paper in Form 2B.
By deleting part 2 of Form 2B, the respondent Mohammed Mokim has complied with the provisions of law as well as the instructions given in the nomination Form 2B itself.
Yes.
By deleting part 2 in his nomination papers कर दियंतु, comma the respondent in Form 2B, comma the respondent has complied with. Sir, कौन comply
Complied with the provisions of law as
Sir.
well as the instructions given in the nomination Form 2B itself.
Itself. Sir, next.
Deletion of part 2 of Form 2B by the respondent cannot be categorized as a defect of substantial character.
Yes.
Conclusion.
Yes.
Deletion of part 2 in the nomination paper in Form 2B by the respondent is not a defect of substantial character. Stop.
The second proviso to subsection 1 of section 33 of the RP Act 1951 prescribes no nomination paper shall be delivered to the returning officer on a day which is a public holiday.
Yes, yes.
Second proviso. The second proviso to section 33 bracket 1 of the RP Act prescribes that no nomination paper shall be delivered to the returning officer on a day which is a public holiday.
In the instant case, respondent Mohammed Mokim delivered his 4 sets of nomination paper on 2/4/2019, which is not a public holiday.
The respondent delivered his 4 sets of nomination papers in Form 2B on 2/4/2019, which was not a public holiday. So, public holiday public holiday.
On the same day,
respondent
on the same day, that is on 2/4/2019, apart from respondent Mohammed Mokim, election petitioner Devashish Samantrai also filed his 4 sets of nomination papers to you.
The election petitioner
as well as Bharatiya Janata Party candidate, namely Samir De,
Bharatiya Janata Party candidate Mr. Samir De,
and
city election petitioner Devashish Samantrai. Devashish Samantrai.
Devashish SHISH.
Allah, ठीक है जी. As well as Bharatiya Janata Party candidate Mr. Samir De, आउ किए. And
Shital Kinnar,
Bharata Hindu Mahasabha candidate.
Akhila
Bharata Hindu Mahasabha candidate Shital Kinnar also filed 1 set of her nomination.
Akhila Bharatiya कौन कहले? Hindu Mahasabha.
Bharat Bharatiya no. Akhila Bharat. Akhil. L पर A रही बने. Bharat Hindu Mahasabha. Prabha
uh,
candidate,
namely
Sital Kumar.
Kinner.
Sital, S-E-E-T-A-L. Kinner.
also filed their nomination papers on 2/4/2019.
Which will be evident
from Exhibit AK.
Which should be evident from Exhibit AK. Stop.
Subsection 2 of Section 33 of the RP Act prescribes.
One is not relevant for this purpose. One এটা দেখি দিও তো আপনারা সেটা দেখি দিও
नहीं आपने तो क्वेश्चन पचाने से कहीं देखिए we come to 2 Roman 2
Subsection 2 of Section 33 of the RP Act 1951 prescribes that in a constituency where any seat is reserved, a candidate shall not be deemed to be qualified to be chosen to fill that seat unless his nomination paper contains a declaration by him specifying the particular caste or tribe of which he is a member, and in relation to the area in which that caste or tribe is a scheduled caste or scheduled tribe, in the case may be as the case may be scheduled tribe of that state.
ये तो जायज सर
जायज
এটা जायज
এটা পুরো আপনারা আইবে যে প্যারাগ্রাফ 8
No.
এর রিলেশন অফ
अच्छा ये सेक्शन नहीं नहीं सेक्शन 33(2) of the RP Act लिखी दो section 33 bracketed 2 of the RP Act
prescribe
is not applicable দরকার নেই is not applicable in the case in hand as 90
সেটা দেখুন তো সেকশনটা পড়ুন unless his nomination paper contains a declaration जो declarationটা সে nomination paper রে কাটি ଦେଇଛନ୍ତି जोटा कि
no that applies to any seat for reserve the first ones the first is not ଅନ୍ୟ ଗୁଡା କଣ ଦରକାର ତେଣୁ this is not applicable 33(2) at all
paper ରେ ଯୋଉ paragraphଟା କହୁଥିଲେ ସେ part 3 ରେ
আরে বাবু সে প্রথমটা আগে দরকার যে ক্যান্ডিডেট সে সিটটা রিজার্ভ হইতিবা দরকার এটা তো সিটটা রিজার্ভ নয় তেমন ଆଉ সেই provision is not applicable in the case in hand as the 90 Baravati Kota constituency is a general seat bas
and not reserved for SC or ST candidates.
Yes.
Therefore, the nomination paper does not require a declaration by the candidate specifying the particular caste or tribe of the candidate.
Yes. So tomorrow it will be over because no, sir, you have assured to finish it
by 20th. We will complete it by 20th.
Sir. Tomorrow, sir, say at
2.
Okay. Post it to tomorrow. नहीं कारण सर तांकु मु कहिछि से 20th रे देई देबे तांकर जो मेमोटा देई देबे then you will be provided with the certified copy and a date will be fixed for the filing of evidence affidavit of the and also the respondent will come and rest of the thing you will say about on that day evidence affidavit जो present हो
तांको आउथरे न देखबे
काबू
आरो
आउ कहीं रखियो
नहीं मैं चेष्टा कर हमर दरकार हबन सेहि भाई मु सब टच करी
नहीं but they have assured that they will file the memo by 20th ତେଣୁ ଆପଣ
ସିଏ ଆମକୁ ଫାଇଲ କରି ଦିଅନ୍ତୁ ଆପଣ ଆମକୁ 4-6 ଦିନ ଦେବେ ଟାଇମ ଟୁ ଗେଟ୍
ସାର୍ଟିଫାଇଡ କପି ସାର୍ ମୁଁ କହିଦେବି ଆପଣଙ୍କୁ you will get it by 25th
ସେ ସାର୍ଟିଫାଇଡ କପି ଲାଷ୍ଟ ରୁ ଦଉଛନ୍ତି ଭଲ ଗୁଣ ହେଲା ବେଳକୁ ତାଙ୍କୁ କିଛି ବୁଝି ହଉନି ସେ କୋଉଥିରେ କଣ ଭର୍ତ୍ତି ହେଇଛି ମୁଁ ଯଦି ବଞ୍ଚଟା ରଖିବି ଆପଣ ଗାଳି ଦେବେ ସେମାନେ
No, no,
ସଜେଇ ବି ପାରୁନି
25th ଭିତରେ because 20th ରେ ଆହୁରି 4 ଦିନ 5 ଦିନ ଅଛି ସେମାନେ let them give
separate application
then but you have already started preparation for the evidence affidavit, so try to give it by 28th so that we can
30th ରେ ତ
okay 30th ରେ 30th is a Sunday so 31st
31st
we'll fix a date. We'll fix a date on 31st. So let Mr. Mukim also come on that day. So he is to be administered oath and deposed, and whatever further chief you want to do also on that day, you may do, and then we'll continue thereafter. So this is tentative arrangement. I will ensure that you get the certified copy by 25th.
He has been suspended from Congress party.
No, he can adduce evidence on that.
ନାଇଁ ନାଇଁ ସେଥିରେ କିଛି ପ୍ରତିବନ୍ଧକ ନାହିଁ କିନ୍ତୁ ଆମେ ଟିକେ ବୁଝି ଦେଇକିରି କହିବୁ ତାକୁ କୋଉ ଦିନ ଆସିବ ଯୋଉ ଦିନ କାହିଁକିନା ଯୋଉ ଦିନ ଆମେ
ଗୋଟେ ଡାକେ ତାକୁ ମାନେ ପର୍ସନାଲ
ଯୋଉ ଦିନ ଆମେ ତାଙ୍କ ଏଭିଡେନ୍ସ ଦାଖଲ କରିବୁ ସେଇଦିନ ଆମେ ତାଙ୍କୁ ଡାକିବୁ
Sir, till that the court has fixed the date, so they can seek for adjournment. There is no problem. That would be better.
ଆଜି ହେଲା କାଲି
ସେ ଆସିନ ମଝିରେ ମିଷ୍ଟର କାନୁନଗୋ ଥିଲେ ତ ଏ ସମୟ ଥିଲେ
ଆଜି କେତେ ତାରିଖ
ଆଜି 17 କାଲି
18
18th July at 2 p.m. sir.
2
Okay, ठीक